So welcome to the 2016 Rehnquist Center Constitution Day program. And thank you all for coming. I'm going to give a brief introduction to our panelists and our moderator, and then we'll jump right in, try to stay on time. To my immediate right is Lisa Mannheim. She's an assistant professor at the University of Washington School of Law, where she's taught for the past 5 years. She teaches constitutional law, federal courts, and election law. Prior to joining academia, she was an associate at Perkins Coie in Seattle and served as a law clerk to Judge Pierre Laval of the U.S. Court of Appeals for the Second Circuit and also for Justice Kennedy on the U.S. Supreme Court. Sitting next to Lisa is Greg Garr, who is Global Chair of Latham & Watkins Supreme Court and Appellate Practice. Mr. Garr served in the Solicitor General's office for 9 years, including as the 44th Solicitor General of the United States. And I learned today is the only person to have served as an assistant to the SG, the principal deputy solicitor general, and the solicitor general. He's argued 41 cases before the Supreme Court, received his JD from GW University, and served as a law clerk to Judge Anthony Sirica on the Court of Appeals for the Third Circuit, and then clerk for Chief Justice Rehnquist on the U.S. Supreme Court. Next to Greg is Robert Yabalon, who's an assistant professor at the University of Wisconsin Law School, teaches civil procedure and federal jurisdiction. Prior to teaching, he worked in private practice at Orrick, Harrington, and Sutcliffe in San Francisco and DC. And he served as a law clerk to Judge William Fletcher of the Court of Appeals for the Ninth Circuit, and also for Justices Ruth Bader Ginsburg and Sonia Sotomayor. He received his JD from Yale Law School, and I forgot to mention that Professor Mannheim also received her JD from Yale. Dave Marcus also received, it's a kind of a pattern here. Sitting next to Professor Yabalon is Justice Clint Bollock of the Arizona Supreme Court. Justice Bollock, prior to being named to the court, co-founded the Institute for Justice, served as president and general counsel of the Alliance for School Choice, and most recently served for 9 years as the Vice President for Litigation at the Goldwater Institute in Phoenix. Justice Bollock received his JD from the University of California at Davis, and he also served as a commencement speaker for the class of 2016 last year. Very enjoyable. Our moderator today is our own Professor Dave Marcus, who's done this for, I don't know how many years running.
20, 30, 40.
Yes. Professor Marcus has taught here for 10 years with a focus on civil procedure and complex civil litigation. He was named by the university as an 1885 Society Distinguished Scholar, a designation that recognizes his leadership, scholarship, and creative contributions to the university and to the profession. He continues the trend of Yale Law School, and he also clerked for Judge William Fletcher on the U.S. Court of Appeals for the Ninth Circuit. He's been selected Professor of the Year twice here at the U of A and once when he was a visiting professor at Yale. Professor Marcus graciously agrees each year to moderate this program, and his involvement really is what makes it so wonderful. So please help me thank Professor Marcus and the panelists.
Okay, I'm delighted to have a chance to participate in Constitution Day again. I'm particularly delighted this year. I think that the lineup we have of panelists is as good, if not better, than any we've had in the past. So it should be a wonderful discussion. I will spend about, well, I timed it. It's 11 and a half minutes per case, summarizing the case that we'll be discussing. And then I will have some questions for the panelists, but really just invite them to give us their thoughts and what I hope will be a informal and sort of interaction among them. I've been recruited to summarize the cases for 2 reasons. The first is we don't want to necessarily assume that you have read the opinions and in the 3 cases we'll discuss today. But number 2, the second reason is I know very little about constitutional law. Sally Ryder and Andy Cohen know that I've never let my lack of knowledge or preparation dissuade me from strongly voiced but ill-supported opinions. So when the panelists correct me, they will look all the better. In other words, I consider myself part of the hospitality that we extend to our distinguished guests here at the University of Arizona so they can go home and think fondly of their experience. My job is to give you some background about these cases while foaming at the mouth, and then I'll turn things over to the real experts. So I think we're beginning with the Fisher case. Yes, the Fisher case first. All right. The University of Texas looms large in the state of Texas. I grew up in Austin, where I raced track for my high school. I had a friendly rival against whom I raced for 4 years. When we finished our last race, his grandfather came up to me to shake my hand and wish me luck in my future endeavors. He said to me, "I assume you'll be starting at the University of Texas in the fall." And I said, "No, I've chosen to go to college on the East Coast." He stared at me as if I were crazy. Why on earth would anyone turn down the opportunity to be a Longhorn? After a long pause, he said, "Well, don't you come back here talking funny." Abigail Fisher, who was white, had a decent but not great GPA and a decent but not great SAT score when she applied to UT. She was rejected. Now, a number of Fisher's family members had gone to UT, so the denial came as quite a blow. It also came as a blow because of UT's cultural significance in the state. It just so happens that Fisher's family is friends with a guy named Edward Blum. Blum is a one-man litigation machine hell-bent on ending and having American law recognize race in any way. He's the man behind the litigation that ultimately gutted the Voting Rights Act, for instance. Fisher became Blum's plaintiff for his long-desired challenge to affirmative action policies at universities. Fisher alleged that Texas's affirmative action policy violated the Equal Protection Clause. What ensued was an 8-year odyssey with 2 trips to the Supreme Court, adding to Solicitor General Garr's notches on his Supreme Court, whatever it is, bedstand, belt, I don't know. Ultimately, the court, in a 4-3 decision, upheld Texas's policy. Now, the constitutional law of affirmative action is completely wacky. It is a result of the idiosyncratic views of 2 justices. It turns these cases into an elaborate dance around what they're really about, and it creates many odd and arguably perverse ironies. I'll try to situate Fisher in this crazy quilt of constitutional insanity and then get back to the case. An affirmative action policy classifies based on race, and for this reason is constitutionally suspect under the Equal Protection Clause. To survive strict scrutiny review, the policy must be narrowly tailored to serve a compelling government interest. In the famous 1978 Bakke case, 5 justices agreed that affirmative action, properly pursued, could be constitutional. But the swing justice, Lewis Powell, refused to accept remedying the effects of societal discrimination as a compelling government interest. In so doing, I believe Justice Powell denied the obvious. If there is a justification for affirmative action, surely it has to do with the structural discrimination against particular groups in American life. But Justice Powell would have none of this. To him, the only compelling government interest was in the attainment of the educational benefits that flow from a diverse student body. Justice Powell's concurring opinion lay in legal limbo for a number of years. In fact, in 1996, the Fifth Circuit struck down the University of Texas's then existing affirmative action policy in its Hopwood decision, concluding that Justice Powell's diversity rationale had never gained the force of law. In 2003, however, the Supreme Court majority in Grutter versus Bollinger confirmed that diversity is indeed a compelling government interest. A single swing justice, Justice O'Connor, compelled this result. Presumably, the other 4 justices who joined her did so because they wanted to preserve affirmative action and not necessarily because they agreed with the rigor or merits of her analysis. So our law of affirmative action flows from the idiosyncratic views of 2 justices expressed 25 years apart. Now, the embrace of diversity as the only compelling state interest to support affirmative action has had major implications for the design of an affirmative action regime. If it is diversity in education that a university wants, a quota system won't do. It's not narrowly tailored to this compelling interest. A lot of traits are correlated with diversity, with the diversity of viewpoints, perspectives, and the like that benefit education. Race is just one of these. An affirmative action policy can't use race crudely. Race must be a factor in an otherwise holistic review of applications. Race is a means to an end of a diverse student body and not the end in and of itself. There must be other means to this end as well. The history of UT's affirmative action policy reflects the tortured history of this doctrine. After the Fifth Circuit invalidated UT's old plan in Hopwood, the Texas State Legislature responded with its Top 10% plan. The top 10% of all Texas high school graduates would be guaranteed admission to a Texas university. The premise of this plan is ironic and reflects the reality that Justice Powell refused to accept in Bakke. The existence of all black and all Latino high schools in Texas would guarantee the admission of a certain number of minority applicants to UT, without UT having to inquire explicitly into race when reviewing applications. In other words, it's the ongoing systemic structural discrimination in American life that produces residential segregation, which would otherwise be bad, but for the backdoor route it creates to a diverse undergraduate student body. When the court decided Grutter in 2003, the University of Texas amended its plan. It determined that this top 10% plan wasn't sufficient to wasn't sufficient to ensure the diverse student body that the University of Texas believed it needed. It was not enough. It was not admitting enough students to create the critical mass of diversity the school desired. So UT adopted a new policy for the 25% of its undergraduate class that's not admitted through that top 10% program. Along with an applicant's SAT score and GPA, UT would consider a bunch of factors for each person, including socioeconomic status, whether the person grew up in a single-family household, the language spoken at home, and, of course, race. This was this holistic review that Grutter required. Abigail Fisher didn't finish in the top 10% of her high school class, and thus she was denied one of the seats left over for the 25% of applicants who proceed through this holistic review. Now, only 5 minority students with lower scores than Abigail Fisher were admitted, and 168 Black and Latinos applicants with better scores were denied admission. Yet Fisher believes that it was this post-Grutter holistic review policy that denied her ticket to UT. Fisher's 8-year lawsuit ended with the court's decision this past June. And there's irony upon irony in Justice Kennedy's majority opinion. Here's one. Fisher argued that UT had not articulated its compelling interest with sufficient particularity. Without knowing precisely what number of minority students UT needs to reach a critical mass, she insisted it's impossible to know if the holistic plan is narrowly tailored to achieving the goal. Had UT articulated the number of minority students it needs more precisely, however, it would have effectively implemented a quota. And this is what Bakke and Gredinger forbid. Kennedy agreed that simply saying that diversity creates educational benefits is not sufficiently precise. But UT had stated its compelling interest more precisely, he said. UT has an interest in, quote, the destruction of stereotypes, and, quote, the promotion of cross-racial understanding. Now, I agree with Justice Kennedy's opinion as much as the next hippy-dippy liberal, but let's not kid ourselves and say that these are precisely stated goals. Kennedy makes short work of 2 of Fisher's other arguments. She argues that UT had already reached a critical mass of minority students with its top 10% plan and didn't need the holistic review in addition. Moreover, she said the holistic review was ineffective at adding to the diversity of UT's student body. Kennedy responds with some statistics. He notes, for instance, that the holistic plan increased Latino enrollment by, from 11% to 17%, and African American enrollment from 3.5% to 6.8%. But another response points to a second irony. The fact that the holistic plan has had so little effect on UT's diversity, Justice Kennedy suggests, simply shows how narrowly tailored it is. In other words, the plan doesn't work very well, and therefore it's constitutional. Okay, that's, I admit, somewhat of a caricature of his argument. Finally, Fisher argues other ways to achieve diversity without a race-conscious admissions policy. Why not admit all UT students through something like the top 10% plan, one that is nominally race-neutral? And now here lie ironies numbers 3 and 4. Number 3, the top 10% plan is all about race, and to say otherwise is to pretend that something is not true that is. And number 4, had this been UT's policy, Fisher's chances of admittance would have plummeted to 0 because she didn't finish in the top 10% of her high school class. One of Justice Kennedy's responses to the extend the top 10% argument unveils something that I find somewhat troubling about the diversity rationale itself. Again, the success of the top 10% plan is premised on residential segregation. If there are enough all-Black or all-Latino high schools in Texas, then we're going to get a lot of minority matriculants. Now, I can tell you from personal experience that most of these schools that are significantly minority are also poor high schools. But the plan does not account for Black and Latino students who attend the rich, mostly all-white schools. UT needs the flexibility to admit some of these students too, Justice Kennedy says, quite reasonably arguing that we don't want to penalize parents for the decision to send their children to better schools. Justice Alito makes a powerful point about this argument in an otherwise remarkably tedious 50-page dissent that's just all that screams, please, edit me. Is UT engaged in some sort of perverse racial accounting? Sure, it's great to get a lot of poor Black and Latino kids, but a diverse student body also needs rich Black and Latino kids. To Alito, Justice Kennedy seems to argue that The race-neutral alternative, extend the top 10% plan, would admit, to quote Justice Alito, the wrong kind of African American and Hispanic students, namely students from poor families. I'm left with a feeling that the diversity rationale leads to all but blatant racial commodification. I certainly don't agree with Justice Thomas's typically nuanced and fine-grained dissent. All affirmative action is unconstitutional. Rather, I regret that the societal discrimination rationale could not command Justice Powell's vote in Bakke, and that we've been stuck in the morass of the diversity rationale since then. Just a couple more ironies and then I'll stop. If diversity in education is indeed the compelling state interest, then ironically, a better education trumps the fundamental right, not to be classified on the basis of race. We would never accept, for instance, a law that prohibited married students from attending law school, even if we could show that without the distractions of a spouse, a student actually performs better and receives a better education. Marriage is a fundamental right and couldn't be trumped by a better education. Irony number 2, if diversity in education is the compelling state interest, then ironically, affirmative action seems to exist primarily to benefit white students. Diversity is supposed to improve the educational experience of all enrolled at a university, and I don't doubt that it does. But the majority of UT students are white, so by the logic of the diversity rationale, most beneficiaries of affirmative action are white. To quote Justice Scalia, the American people are not fools. The diversity rationale is transparently dishonest, but maybe Fisher will end decades of attacks on university affirmative action policies and at least spare us the kabuki dance that these cases seem to require. Okay, that's my 11 minutes and 30 seconds. I would like to invite the panel to react to anything I've said or say anything else, but I'd like to start with Mr. Garr, since Craig Garr actually argued both Fisher cases, and just get your thoughts as to what I've said, or if anything I've said that's incorrect, or that needs a more nuanced fleshing out, or the like.
Sure, I confess that my head is spinning a little bit in ironies. I think that that's certainly generally speaking, an accurate description of the evolution of the case law here. In particular, the fact that the Supreme Court, going back to Bakke and Justice Powell's opinion, has rejected the goal of remedying past discrimination as a compelling interest in this area for the consideration of race in higher education. And that did lead to some interesting moments, created some interesting moments for me during the oral argument, where a couple of times, I think maybe in both cases, Justice Alito pressed me about, wasn't it really the interest at the end of the day in all this is to help less fortunate minority students? And the Supreme Court had not accepted that as a compelling interest in this area. So what they did accept was the compelling interest in pursuing the educational benefits of diversity. It's what's laid out in Justice Powell's opinion. It's what the Supreme Court in the Grutter case accepted by a 5-4 decision written by Justice O'Connor. And that decision spoke a lot about creating pathways to leadership, educating students from different backgrounds and different races in a diverse environment in which they could go on to succeed. And if you go back to the Grutter cases, one of the, maybe critical aspects of that case was a brief filed on behalf of retired generals that talked about the importance of diversity in the military, in the military academies. And it may be that amicus brief itself actually turned the case with Justice O'Connor. So there was the Supreme Court has adopted that diversity rationale, notwithstanding its arguable elasticity. I think, though, that what that also points out is that in this area, there are really sort of, two ways to go. One is the question of what is the compelling interest, and the other is, is the plan narrowly tailored to that interest? And in the Fisher litigation, initially when it got to the Supreme Court, it was more about whether or not the University of Texas's plan was narrowly tailored to the objective, because the plaintiffs in that case chose not to challenge or ask the court to overrule its precedent recognizing diversity as a compelling interest. But as the case got to the Supreme Court the second time, the plaintiff, I think, focused her arguments more on whether or not the interest in diversity and educational benefits of diversity was itself a compelling interest under the Constitution, which I think raised the stakes of the significance of the case and moved a little bit away from whether or not the plan was narrowly tailored. Ultimately, Justice Kennedy's opinion for a 4-3 court was that accepting the diversity rationale is a compelling interest in holding that the plans, the University of Texas plans, narrowly tailored.
Let me just follow up and ask you about this was a 4-3 decision. When you argued the case, there were 8 justices on the court. Or wait, no, 9 justices.
No, there were 8.
There were 8.
Justice Kagan was recused.
Right, Justice Kagan was recused.
Filed a brief as the sort of general case.
So you were arguing before 8 justices, and I would expect that you were hoping for a 4-4 split. So 2 questions. First, to what extent did you, when you prepared as an advocate, were you trying to pitch your argument to Justice Kennedy as the anticipated swing justice? And then second, if you were indeed expecting or hoping for a 4-4 split, would the tie have been as good as a win, given that it would have left the Fifth Circuit's decision in place?
Right. So as to the last point, a tie would have been a win because it would have been an affirmance by an equally divided court, and the Fifth Circuit had upheld the constitutionality of the plan. So it would have been a complete win for the University of Texas. It would not affected other universities in the way that the court's 4-3 decision does. And you're right, going into the case, we had 8 justices. The odds didn't look good for us because we knew that several of them had been adamantly opposed to the consideration of race at all. Justice Kennedy, Justice O'Connor, who wrote the opinion in Grutter, had been replaced by Justice Alito, who, one might look at his writings and conclude that he would look at this issue differently as his opinions in the Fisher case do. And that left us with Justice Kennedy, who had never, in his 30 years on the bench, ever voted to actually uphold an affirmative action policy. But going into the argument, we had 8, and we needed to get 4 to get an affirmance. As to whether or not we pitch it to any particular justice, the answer is, essentially no. Everybody appreciated on both sides the significance of Justice Kennedy's role in this case, and it is often the case in these more hot-button issues. Justice Kennedy finds himself at the middle of the court, but I think it's never a good idea to litigate a case solely to one justice. When you do that, not only do the justices intend not to like it, but oftentimes arguments tend to disassemble a little bit. So I think both sides are sensitive to Justice Kennedy's role in this case, but certainly our objective was not to brief it to one justice, and there were a variety of arguments, including standing arguments, justiciability arguments that I think conceivably could appeal to other justices.
So before I ask more specific questions, I want to invite other panelists just to weigh in on what's been said so far, if you have initial reactions or comments. Or I can ask my pointed questions. Yeah, Justice Pollock.
I'll jump in. And first, I have to, first of all, wish the Constitution a happy 229th birthday. I hope I look as good at that age. And thank you all for being here today, and thank the university and the Rehnquist Center for sponsoring this. I'm really honored to be with my co-panelists and with Professor Marcus. What was the adjective you used before the word liberal when you described it?
Hippy-dippy.
Hippy-dippy. Can I borrow that?
I'd be thrilled if that somehow this made its way into Arizona jurisprudence.
But I have to note my own boundaries. I am not at liberty to comment on pending cases or on issues that are likely to come before my court. But as for decided cases, I am at liberty to praise them or trash them unmercifully. I guess I fall into the latter category here. I am glad to see that Texas has replaced Arizona as the incubator of Supreme Court cases. It was kind of painful to go through that period when we were sending several cases up every year. But I found this, and also I want to congratulate Greg. This was an absolutely amazing job, and it was, I don't know, like the Broncos beating the mighty Panthers last year or something like that, something on that order of magnitude. But just, certainly I don't think anyone with a 7-member court would have predicted not only a victory, but a very strong victory. Having said that, I really found this decision to be extremely unsatisfying and disappointing. And in fact, when I was reading the opinion, it ended before I thought that it got to the gusto, especially the narrow tailoring of a racial preference plan, which I thought, was really going to be the guts of the case. And he kind of Justice Kennedy kind of talks about it, and then it ends, the decision ends. And I refuse to call what's going on in Texas at this point affirmative action, because I really believe that affirmative action, as originally defined, was intended to provide an extra boost to people who had suffered disadvantage or discrimination in the past. But as you read this opinion, it really seems to have transposed, and in fact, in this case, I think Justice Alito makes a compelling case that this is designed to help the most advantaged members of the disadvantaged groups. He quotes from a brief saying, "We want the kid from Andover," and that just astonishes me that you would discriminate against some students and in favor of others to get the most elite members of the preferred group. Professor Marcus mentioned the things that are taken into account in this program in addition to race. First of all, you do have the top 10% program, which I think is an affirmative action program in the true sense, because it's basically saying if you work really hard and overcome your disadvantages, if you manage to get in the top 10% of your high school, you're going to go to a school at the University of Texas. Whether that is racial discrimination or not, perhaps we can discuss in turn, but I do think that that's genuine affirmative action. The other things that were considered here, the socioeconomic status of the applicant's family, the socioeconomic status of the applicant's school, the applicant's family responsibilities, whether the applicant lives in a single-parent home, the applicant's SAT score in relation to the average SAT score in the applicant's school. These are all, to me, genuine affirmative action types of programs that will have the consequence of yielding an increasingly Black and Hispanic student body, just as a school voucher program designed to give advantage or benefits, opportunities to low-income kids, by definition, is going to yield that. But are these legitimate factors? Of course they are. But race is different. And in this case, the Supreme Court, and in particular Justice Kennedy, really, I think, turned the tables of what is required to justify racial discrimination, and basically upholds a very amorphous objective, and does not require an examination of less discriminatory alternatives, which I don't think the defendants in this case possibly could have done. Just one last point, and I'll let my co-panelists jump in on this. Professor Cole, you were talking about how long Justice Alito's dissenting opinion is. There is one reason for that. Every single page has like 6 quotes from citations to decisions that Justice Kennedy made that are completely contradictory to the position he's taking in this case. And I think Justice Alito took great relish, despite being on the losing side, in pointing out the inconsistency of Justice Kennedy. How that can be explained is beyond my capacity.
I wonder if Professor Scanlon or Manheim might be able to explain, to fill in for the limits of Justice Pollack's capacity, or otherwise react to anything that's been said.
So I made the same observation about Alito's dissent, and I actually tried to count up the number of references to Justice Kennedy, and it was at least 15 different times in which he's citing something that Justice Kennedy said in the past and using it against him. So even if the litigants in this case were not tailoring their arguments to Justice Kennedy, Justice Alito was. It almost seemed like he was trying to shame him into coming out the other way. And I don't think Justice Kennedy is one to be shamed in that way. Justice Scalia certainly tried on a number of occasions without success too. But I'll give a qualified defense to his opinion. I'll accept that it is unsatisfying on a number of levels, but the defense is that maybe that is what the moment demanded. This was a 7-justice court that was hearing the case. Justice Kennedy must have been well aware that there was a justice sitting on the sidelines who was likely to agree with the more liberal members of the court that this was okay. And then ultimately the fate of affirmative action programs will likely turn on whoever the 9th justice later gets added to the court, whoever that is. And it would have been awkward to substantially change the law of affirmative action at that point. Do you then have, if he had gone the Justice Alito route, a sea change that takes hold for a year or two before it's reversed? And so preserving the status quo actually was, in many ways, just a very judicious thing that he decided to do in this case. And it probably was a little bit uncomfortable. You know, as was pointed out, this was the first time in 30 years on the court that he actually had ruled in favor of an affirmative action program, but maybe his assessment was that that was just what the circumstances, the institutional circumstances demanded.
Why not a remand in that case to avoid what you're suggesting?
The case had gone on for so long already, and I don't know if others have additional thoughts on that. I mean, he was ready for this one to be done.
Yeah, I would say that's one of the least satisfying parts of the opinion was the question of remand. And it suggests that, as Rob was saying, that maybe this is just what the court concluded it needed to do at this time. And the case had been going, you said, since 2008. Is that when she first applied? So as we were joking, her children at this point, you know, maybe applying to UT in this program. But I would say generally this case indicates to me that the Supreme Court right now is it seems to be in kind of a holding pattern. It seems to be doing what it can to not be reaching out, not be taking on new cases, not to be moving the law a lot, presumably because it is shorthanded. And while I would echo the thought that this opinion was unsatisfying for various reasons, number one, and number two, that I also was surprised that Justice Kennedy, in a sense, switched sides here, because he had not done so in decades on the court. That being said, there is one way that what Justice Kennedy did here was consistent with how he's been with respect to these issues for a while, and that's that he, in the context of racial classifications, he takes a position that drives people nuts, which is he says, yes, the state can use them sometimes, I just don't like the way they did it here. So you have 4 people upset with him for saying, I don't like the way that the state did it here. And you have 4 people upset with him for suggesting that sometimes it's okay. And this is the middle road that he's taken in a number of different contexts. He's also done it with respect to political gerrymandering, for example. And so what was surprising about this case was not that he took this position. I mean, his holding was very, very narrow in this case. He said, the Texas system is one of a kind, which is a big signal, you know, don't start citing this for other programs. I mean, people will, but there's good ammunition for people challenging them, that this is different, Texas is different here. And he also said, you know, in the future, circumstances might change. Someone can go ahead and challenge this same program again in 10 years, and maybe it will be unconstitutional then. But what he did, so he kept this same approach, this narrow approach, but what was different here was that he finally said, yes, that's what I've been talking about, that the state can do it this way. So, you know, was that Texas' program that changed his mind, or was it this moment in time? I don't know, but in that sense, what he did here was consistent with his jurisprudence.
So it's hard for me to slip out of my advocate's role, so I'm going to try to defend Justice Kennedy and the decision a little bit. First of all, it's Justice Kennedy. I think picking up on what Lisa said, Justice Kennedy had dissented in the prior decision, Grutter, which involved a challenge to Michigan Law School's consideration of racial admissions. But in his dissent in that case, what he said was, Justice Powell had it right in terms of the constitutional framework here, but the Michigan Law School, his plan was not narrowly tailored to achieving the objective because of flaws that he found in that plan, including the fact that admissions officials allegedly were tracking numbers during the course of the process to get to what he thought was a quota. I think that the facts of the Texas case look fundamentally different than that. And you know, going back to Justice Bollock's point as to whether or not the university tried other ways, I mean, this case really involved overwhelming evidence that the University of Texas had tried to achieve student body diversity without the consideration of race. In fact, it had done so for 7 years during the period that the Fifth Circuit had held the consideration of race was unconstitutional before the Supreme Court held that you could consider it. It had tried that with its percentage plan in place for 7 years, and African American enrollment had plummeted almost overnight, and it got to the point where there were about 300 entering students out of a class of 7,000 who were African American, and the University of Texas said, for the finest public educational institution in the South, one in the country, that was unacceptable. And so it then instituted this plan of considering race as one part of this holistic framework, including the other factors that Justice Pollock recognized, and immediately that did have an impact. So actually, I think that the facts of this case, which Justice Kennedy did emphasize in his opinion, did I think support Texas very much in showing that the plan was narrowly tailored to that objective.
Justice Pollock, what do you think? Texas tried for 7 years, didn't work as well as it had hoped, and so changed its plan. How would you respond?
Well, I will plunge a little bit into policy here, as I've addressed this for throughout my career, but I think that's bound to happen. And the reason it's bound to happen is that, actually, I'll quote a cab driver one time when I was in DC. I did a show on NPR, and it turned out the cab driver had heard the show, and when I got into his car, he said, what they don't understand is that the problem is not in college, the problem is in kindergarten. And one of the things that frustrates me about adding points to kids' test scores or to their applications on the basis of race is it creates a cosmetic illusion that we are solving very serious underlying social problems, when in fact the problems are as bad as they were 20 years ago, if not worse. I remember when racial preferences were abolished in California through the voter initiative to amend the Constitution there, and Berkeley said, we're not going to take this sitting down. We're going to go out into the community and send our students out as tutors. And we're going to do all sorts of other interventions in local schools and boost the number of kids who can compete for admission into the University of California. And I said to myself, presto, this is what we have needed all along. But we don't get to that so long as we have an easy fix. And as time goes on, when we become not only a multiracial society, but multiracial individuals, the notion of dividing people up on the basis of race and assigning a benefit or a burden on that basis just becomes, I think, increasingly difficult. All of which underscores to me the wisdom of the framers of the 14th Amendment when they created an equal protection clause, and the unwisdom, the foolishness of the court in Plessy versus Ferguson when they led us into the abyss of race being sometimes okay for government to assign benefits and burdens. So that may be a bit more than or less than you were looking for, but that's
exactly what I was looking for.
Okay.
I want to leave time, 10 minutes, for the audience to ask questions of the panelists about this case, as we'll do for each of the discussions we'll have. But one last question for the professors. You both identified an institutional explanation for the outcome in this case. There's an 8th justice sitting on the sidelines, a 9th justice to be appointed. That Justice Kennedy is aware of the fact that he's in this role for the first time, and that's significant. What do you think of what the future holds? Was Justice Kennedy invited? He mentioned at the outset that he found it striking as curious that the plaintiffs did not challenge the top 10% plan. Was he inviting a challenge to this plan? Do you think that the opinion leaves room for challenges to affirmative action plans at university going forward? What is that room? I'd just like to hear from you, your thoughts on that.
Sure. So there has been, in the jurisprudence relating to these issues, there's been a big divide between, on the one hand, when a state makes a decision based on the race of the individual, that's on the one hand, and on the other hand, when the state makes a decision, even when it has racial issues in mind, without looking to the race of individual people. In the first category, strict scrutiny applies. In the second category, strict scrutiny is generally not applied, number one. And number two, the court actually encourages those sorts of means as an alternative to the use of the racial classifications of individuals. As Justice Bullock said before, one thing that the University of Berkeley did, I mean, I was not aware of that myself, but it makes sense, was to send people out in an effort to boost enrollment of people of various races. To be clear, that's a racial motivation in what the university did. But because the university wasn't looking to the race of individual people in making decisions, that is not the sort of thing that the court is worried about, is skeptical about. My understanding of the Top 10 program, as well as I think Arizona has something similar, is that falls into the latter category. So quite to the contrary, right now, at least under current law, the court would be encouraging those sorts of programs as a way of avoiding constitutional problems.
And Justice Kennedy does criticize the program in his opinion, but I don't think that he was criticizing it in the sense that he was inviting a legal challenge to it, but instead suggesting that as a policy matter, it is an inadequate alternative to the holistic review that Texas was doing as a supplement. But he in particular has been in favor of facially neutral but race-conscious alternatives to formal racial classifications. And so, although as a policy matter you might say that the top 10% plan should not stand on its own, other things like that I think he would generally be supportive of and not view it as an equal protection problem, for example.
Well, we have about 10 minutes left in the session. I'd like to invite anyone in the audience who's got a question to raise their hand. Yes.
I think this is a question for Greg. Was standing ever an issue in this case? Was she able somehow to prove some kind of causation that it was because she was white, and was that just kind of washed over as it progressed?
Well, we tried to make it an issue, not successfully ultimately. I mean, it's a very strange case in that most of these sorts of challenges are brought as class actions on behalf of current students and future students, applicants. This case was brought solely on her own behalf, so she requested her claims for injunctive relief fell out when she graduated from a different university. So all we had remaining in the case was a plaintiff who had graduated from the University of Texas years ago, who was seeking the return of a deposit that she would have paid even if she had been admitted. So I actually think that there was a very strong argument against justiciability that she didn't have standing for addressability reasons. She was also in an unusual position in that the record showed that no one with her academic credentials, no matter what their race, was actually admitted through this holistic policy her year. And so, that was the case was decided on summary judgment. They disputed that ultimately factually, but that's what the record showed. So it made her. I think that did raise justiciability issues. We raised it twice before the Supreme Court, and no justice addressed it.
When Bakke was decided, the Harvard Law School program was cited as the example that was great. And the theory, which I love Harvard saying, was that the real beneficiaries of this program are white insulated men, and that they would now have the opportunity to be exposed to other people, like people who play the violin, people who came from the West Coast, etc. And that was cited by the Supreme Court as a good affirmative action policy, good goal, and the policy was, I think, cited as a good example. And I know afterwards, we had to draft these things up. It wasn't easy, but we tried to do something like that. I'm wondering if that still applies. The ultimate goal seems reasonable. How do you do it? I don't know if you ever drafted one, but it's not easy. You have a structure, and then you have implementation, and people screw up. But the ultimate goal is to have a diverse group, which is beneficial to society. I don't know if you ever drafted one. Try it. It's not so easy. And you know damn well you're going to get sued. But eventually, if you're a big enough employer. But is Bakke still a good example of something that would pass muster, you think?
Well, you're right. I mean, it was the Harvard plan that Justice Powell actually appended to his opinion in Bakke, and the Supreme Court has referred to that. So I think you're right as to that. I mean, one of the ironies of the Texas case was that ultimately the plaintiff claimed that one of the flaws in Texas's program was that the consideration of race was too minor to be constitutional because the university had made it, a factor of a factor of a factor in the way that they considered it. And the Supreme Court, and Justice Kennedy in his decision, ultimately agreed with us that that wasn't a constitutional flaw. It was something that we would be looking for in a properly revised program.
You're also right that you'll likely get sued no matter what. So that the Harvard plan, which the Supreme Court praised in Bakke, is still basically in effect, and Harvard recently was sued. And it's sued, I believe by the same people who brought this litigation, and since it's a private institution, it's under the Civil Rights Act rather than the Equal Protection Clause, but the claim is actually that they are discriminating against Asian Americans and have effectively imposed an implicit quota on the number of Asian Americans who they will allow in.
On the application for the Arizona Supreme Court, there is a question about diversity. And what's interesting about that question is it doesn't refer to race, gender, ethnicity at all. It simply says, if you have anything that you bring with you that will diversify the institution. And there's a whole host of possible answers to that. My own law school, I diversified ideologically pretty profoundly. I was probably the only student. It happened that Bakke graduated med school from my university the same year I graduated from law school. I was probably the only person who supported him in my entire law school. So I think that if you individualize it, it happens that if people grow up in disadvantaged circumstances, whether they're white or black, Hispanic or Asian, chances are they're going to bring something distinctive to the educational experience. And if what you are genuinely valuing is diversity, and you are willing to not use race as an automatic proxy for that, not only do I think you'll get a diverse student body in a genuine sense, along with these other factors that the university is already using, but I can pretty well guarantee you won't get to. Elliot.
I was just wondering, I mean, I've no great expertise in this area, but I've always been frustrated by the ephemeral nature of the tests that the court has set forth in these various opinions. But I find myself wondering whether the motivation is that race remains such an explosive and divisive issue in our society that if they were to hand down an opinion with some kind of clear-cut lines, it would just become a point of controversy, an explosive kind of controversy, in the kind, for example, that has come up over the abortion issue. And that, to that extent, the ephemeral nature of the test and the kind of games playing that universities engage in to satisfy whatever the current test is a way also of sort of diffusing the issue.
I think that if you spoke with some members of the court, I think they would agree with that. And I think they even are somewhat explicit about that. So, again, Justice Kennedy, for example, has suggested that there's a harm that occurs simply by virtue of a state taking an action with respect to an individual based on an individual's race. It doesn't matter what the action is. It's just treating someone a certain way because of that person's race is a harm in and of itself. So the extent that you have a program, for example, the one in Texas, where they, among the things they do that I think were probably important to the court were, number one, and correct me if I'm wrong, but the race of each applicant is identified by the applicant, him or herself. It's not as though somebody is second guessing what people are putting down. So the state's not making that determination, number one. And number two, it's sort of, there's a process by which the person who in the admissions process who knows the applicant's race is not the same person who ultimately decides who gets in and who doesn't get in. And so what this means is that at no point is the ultimate decision directly a response to somebody's race, if that makes sense. And I suspect that for someone like Justice Kennedy, that made a difference, because it does obscure it in a way that he would say is a virtue. It's a feature, not a bug, I guess is what he might say.
It's close to what he did say.
Well, there you go, right.
Andy?
This is mostly a question for Justice Bowen. Did the framers of the 14th Amendment intend to prohibit race-based affirmative action? And if so, why don't we see more discussion of that fact by people like Justice, in the opinions of judges like Justice Thomas and Justice Scalia?
So, can you repeat just the last part? And if so,
Right. Why don't we see more discussion of that fact in the opinions of people like Justice Thomas and Justice Scalia?
well, I think if you look at the plain words of the Equal Protection Clause, and as a textualist, that for me is the main thing. You know, the words don't admit of variation. If you look at the history of the Equal Protection Clause, the history is pretty mixed, because you had a segregated national capital at that time. These were some of the considerations that went into Brown versus Board of Education, for example. So I do think that that is a valid discussion, and Justice Thomas, as you know more than anyone else, has brought this into the fore. That if you have an equal protection clause that does not contain exceptions, how on earth did we get to a point where we've got all sorts of exceptions to it? And it wasn't Thomas. Interestingly, there was a case, and my con law colleagues here may remember the name of it. Was it DeFinis that predated Bakke, where the court denied cert? And Justice Douglas, of all people, wrote, I believe, if my memory serves, a really scathing dissent to the denial of cert in that case. And it was very similar to what Justice Thomas says today. I remember him saying that the Equal Protection Clause has an accordion-like quality to it if it applies differently to different people. But I think that's a very important consideration. And I do note that in the year 2016, we now have diverted from an absolutist perspective of the Equal Protection Clause for many, many, many generations, and it doesn't seem to be drawing us together. And if anything, it seems like we have as much division as ever.
Okay, we have reached the end of this first session, so we'll continue on. We're going to take a break after our discussion of the whole woman's health case, but we're going to proceed on and turn to abortion. Race is not sufficiently controversial, so let's raise the temperature. Okay, now we're going to keep plugging. Yes, not taking a break yet. Sorry, back in the whip. I've been told that I'm supposed to be funny in these presentations, but I had a hard time figuring out what was funny about abortion, so I Googled jokes about abortion. I think my laptop needs to be thoroughly disinfected. I don't recommend doing that. I think the main themes of the whole women's health case go to some pretty important questions. Is abortion different, and should it be different? Whole women's health has its roots in the 2010 wave election, one that fundamentally reset the political balance in this country. Republicans won large victories at the state legislative level, and they continue to win such that Republicans now control legislatures in 30 states. Not coincidentally, since 2010, state legislatures have passed 334 abortion restrictions, or 30% of all abortion restrictions enacted since Roe v. Wade was decided in 1973. Now, perhaps the most famous, or arguably infamous, legislative episode happened in Texas in the summer of 2013. On the last day of this legislative session, the Texas State Legislature was about to enact 2 sweeping restrictions on abortion providers. These were the restrictions at issue in whole women's health. First was the admitting privileges requirement. The physician performing an abortion must have admitting privileges at a hospital located no more than 30 miles from the place where the abortion was to be performed. The second was a surgical center requirement. The minimum standards for an abortion facility must meet or be equivalent to the minimum standards for an ambulatory surgical center, that is, a full-fledged hospital. Now, it was clear to anyone who was observing what the Texas legislature intended by these measures. The pretext was that these measures are intended to protect women's health, but that's obviously not true. The admitting privileges requirement, for example, Texas already had a law that required abortion providers to have arrangements with local hospitals in the case of complications. As for the surgical center requirement, this would have required abortion providers to have operating rooms, extra wide hallways for stretchers, advanced heating and cooling systems, large nursing staffs, and so forth. But it turns out abortions are safer than, say, colonoscopies, tonsillectomies, a lot of dental work, and of course none of that has to be performed in the equivalent of a full-fledged hospital. What the Texas legislature really wanted to do was shut down abortion clinics. It turns out that it's pretty hard to get admitting privileges at hospitals, and it's really expensive for abortion providers to revamp their facilities to meet the requirements for surgical centers. So Texas wanted abortion providers in all but the biggest of its cities to shut down. Over the course of 11 dramatic hours, Wendy Davis, wearing her now famous pink running shoes, filibustered the bill to death, creating a national phenomenon, but that didn't exactly work. Rick Perry called a special session of the legislature, and it passed abortion provider restrictions overwhelmingly. The law had exactly the effect intended. By October 2013, when the admitting privileges requirement went into effect, the number of abortion providers had dropped from 40 to about 20, with the number of Texas women living of reproductive age living more than 100 miles from an abortion provider increasing by 150%. Had the surgical center requirement gone into effect, this number would have fallen further to about 7 or 8 clinics, with the number of women of reproductive age living more than 100 miles from an abortion provider having increased to about 1.3 million. Several abortion providers sued, alleging that these restrictions ran afoul of the 14th Amendment and its protection of some modicum of access to abortion services. The case followed a complicated procedural history, which I'll get to soon, but for now assume the following. The district court agreed with the plaintiffs and enjoined the law's enforcement. The Fifth Circuit reversed. Now the justices, of course, couldn't wait to get their grubby little paws all over this one, but what guaranteed a grant of cert was a split in the circuits. The Seventh Circuit invalidated a similar set of restrictions that Wisconsin had passed. For a hippy-dippy liberal like me, there's nothing quite so wonderful as listening to Richard Posner, who just wants plausible reasons, grilling a lawyer, trying to defend a law so utterly pretextual as Wisconsin's was. I suggest that you run, don't walk, forget the rest of the session, just go to the nearest laptop, Google 7th Circuit oral arguments, enter 15-1736, and sit back and enjoy the schadenfreude. There is no way that the Supremes are going to let Posner have all the fun, so they granted cert in the Texas case. Voting 5-3, the court ruled that Texas's restrictions are unconstitutional infringements on the 14th Amendment's substantive due process guarantee. Now, my claim is that abortion is different, and the doctrinal background to this case is one reason why. Roe v. Wade in 1973 declared that the right to an abortion is a fundamental right, and thus, using familiar tiers of scrutiny analysis, the laws burdening this right are subject to strict scrutiny. But Planned Parenthood v. Casey, decided in 1992, held that Roe's fundamental right analysis shortchanged the strength of the state's legitimate interest in the protection of what the court called potential life. It adopted the undue burden test. Does a state regulation have the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus? Now, as far as I know, there's no other law allegedly infringing upon the fundamental right is analyzed quite this way. I think it's fair to say there's a different abortion-specific test under the 14th Amendment. I wonder if the Fifth Circuit saw an opening here and trying to make sense of the opinions here make no sense. I spent like 15 or 20 minutes reading them, and I couldn't figure out what the test was, what's the standard. The Fifth Circuit seemed to try to rein in Casey and push abortion jurisprudence towards rational basis review. The Fifth Circuit said, look, we have to accept the Texas legislature's findings as true, that these laws would indeed have protected women's health and were not designed to force clinics to close. Hence, the law serves a legitimate state interest and was not enacted for an unlawful purpose. As for the effect of burdening access to abortion, again, the Fifth Circuit insisted we have to accept the Texas legislature's findings as true and cannot question the benefits of the law. We simply say, would the burden have been substantial? For this to be so, the Fifth Circuit insisted, the law had to reduce access to abortion for a, quote, large fraction of women in Texas. Since, for instance, only 400,000 women of reproductive age would live more than 150 miles from an abortion provider, and there are 5.4 million women of reproductive age in Texas, the law is not an undue burden. The denominator is much larger than the numerator. Now, Justice Breyer had little patience for this analysis in his opinion. First, he made clear that there's no rational basis review involved at all. The undue burden test asks courts to examine both the benefits of the law as well as its burdens. Moreover, courts do not have to defer to legislatures when determining whether there are indeed benefits. The court then examined the benefits and burdens of both requirements and found the balance pretty out of whack. Of course it did. The laws were utterly pretextual. For instance, take the admitting privileges requirement. The benefits were non-existent. 0.25% of women getting first trimester abortions had complications requiring hospital admissions, and it wasn't as if these women couldn't get admitted to the hospital because the provider lacked admitting privileges. In other words, Texas doesn't seem to suffer from this sort of problem of women bleeding internally, lying on the sidewalk in front of hospitals with getting turned away. Moreover, the burden was significant. Clinics closed in Waco, San Angelo, and Midland due to the requirement that providers had admitting privileges, and more clinics were sure to close had the other requirement gone into effect. The court also took issue with the Fifth Circuit's large fraction analysis. The point is not to examine the effect of a law on those people for whom it is irrelevant. Rather, the point is to look at the effect of a law on the constitutional rights of those people for whom the right means something or has some real-world significance. The majority opinion is replete with this sort of fact-intensive analysis. Justice Alito's dissenting opinion tries to take on these facts to suggest that other reasons, such as, say, the national drop in abortion demand, might have caused the number of abortion providers in Texas to collapse from 40 to 20, coincidentally, just as the admitting privileges requirement went into effect, a remarkable coincidence. Moreover, Justice Alito argues the 7 to 8 facilities that would remain in Texas after the surgical center requirement went into effect could simply up their game and compensate for the lost capacity of the closed clinics. Hey, Alito says, abortion's just like shopping for groceries. If Fry's closes, then Safeway's not going to turn away the increased number of customers. It'll simply stock more tuna and Cheerios and hire more cashiers. And abortion's really just the same as tuna and Cheerios. Now, Breyer made short work of this. He didn't use the Cheerios and the tuna analogy, but I think he should have. He made short work of this. He tapped into the experience that each one of us has had reading a bad magazine, drinking from that little cup full of water from the water cooler, and listening to the flu-ridden person hacking up a lung next to us as we wait for a doctor. We disagree, Breyer says, that according to common sense, medical facilities well known for their wait times operate below capacity as a general matter. That's pretty much it for the substantive constitutional law analysis. Justice Thomas, in his dissent, thinks the majority is hell-bent on crafting an abortion-specific jurisprudence of the 14th Amendment. And whether the court really should do that as a sort of generic matter of doctrinal design is an interesting question, but it's sort of a silly objection because the court has been up to this, at least since Casey, if not before. There is, however, one more piece to the whole women's health puzzle, and again it goes to this question of whether abortion is different. Now, most unfortunately for you all, this last piece involves, I'm going to pause for dramatic effect, civil procedure. Now, I know that not everybody here draws a bubble bath with his partner, lights some candles, pours a little champagne, puts on some soft music, and then reads amorously from the federal rules of civil procedure the way that I do most Friday nights. But the civil procedure issue here is really important, and it begs the question yet again, is abortion different? It turns out that when Texas first enacted these restrictions, right after Wendy Davis with her pink sneakers made national news, some of the plaintiffs in this case sued. They brought a facial challenge to the admitting privileges requirement. They lost in the Fifth Circuit and did not petition for certiorari for reasons unknown to me. This case is a second case, brought after the first, So there's an obvious res judicata concern. In fact, to my mind, the first judgment should have precluded both the renewed challenge to the admitting privileges requirement, dressed up as an as-applied challenge, but also the challenge to the surgical center requirement. The black letter law, res judicata, says if you could have brought something the first time and chose not to, you can't now bring it a second time. This is where the heart of Justice Alito's dissent is. It's a lengthy exposition of the law of res judicata, and perhaps accounts for the tepid challenge to the majority's analysis of the merits. I believe that he is right, as much as my bleeding heart hates to admit it. Justice Breyer tries mightily to argue that ordinary res judicata principles aren't triggered here, and ultimately successfully influenced in significant measure by a brief written by Professor Yablon, so I look forward to his explanation of why everything I've said is incorrect. But to my mind, the court reached for an abortion-specific exception, or a fundamental values-specific exception to res judicata, that abortion should be different. Now, maybe it is just those of us with an unhealthy obsession with the integrity of procedure who find this a bit hard to swallow. I can envision many reasons why abortion should be different as a matter of substantive constitutional law, but the case for a different procedural law of abortion is a harder one to make. Okay, I'll stop there, and I'll start by inviting Professor Yablon to tell me why I'm wrong.
Okay, so we get to start with the boring part of this case, I guess, the civil procedure part. We're the only two people who do the civil procedure bubble baths, I think.
Yeah. We'll check. I'll ask you about what music you use and what brand of champagne after. Let's leave that for a private conversation.
So I also value the integrity of civil procedure, and I just disagree on the merits of the civil procedure analysis, I think. So I was the counsel of record in an amicus brief that addressed this issue at the cert stage, and that Justice Breyer then cited in the majority opinion. And there are two parts to this res judicata question. The first is, so you had an initial lawsuit. The initial lawsuit was a pre-enforcement challenge to the admitting privileges requirement of the law. The second suit raised an as-applied challenge after 2 clinics closed because of the admitting privileges requirement. And separately, the second suit raised a challenge to this surgical center requirement. So let's start with the surgical center issue. Should the plaintiffs have raised their challenge to the surgical center issue in the first case, and having failed to do so, should they have been barred for doing so in the second case? And I think the answer there is a pretty clear no, that they did the right thing. When they brought the first litigation, the surgical center provision not only had not taken effect, but regulations had not yet been promulgated to define exactly what the surgical center requirements could be. So the plaintiffs at that point didn't actually even know the extent of the burdens that they would be under. And so it was sensible for them to wait until the regulations came out and to see exactly what they were up against and what the implications were likely to be before they brought suit. And then the argument to the contrary, that they should have challenged every aspect of this statute in their first case, when you think about the world of omnibus statutes that we live in, and that's a tough rule. It suggests that if you want to challenge the Affordable Care Act, for example, you need to parse every phrase in that multi-thousand-page statute and challenge it all in one go. And that's not, we just don't want litigation to look like that. It makes sense to look provision by provision. The slightly harder issue is, should they have had a second crack at the admitting privileges issue? And even there, I think that Justice Alito's proposed rule is a harsh one, and too harsh. So again, this was initially, the first case, a pre-enforcement challenge to the admitting privileges requirement. They went to court and they said, we believe that the consequences of this will be that physicians cannot get admitting privileges and clinics will have to close. The district court agreed with them. The case went up to the Fifth Circuit. The Fifth Circuit basically said, we disagree with that analysis. We don't think that doctors will have a difficult time getting privileges. We don't think clinics will close. Well, guess what? The plaintiffs were right and the Fifth Circuit was wrong. And so now, knowing what the state of the world is, and knowing that the court got it wrong, shouldn't you as a litigant have another opportunity to say, the situation, that there have been subsequent developments, the situation is different from what you, the court, imagined it to be. Let's take that into account. And that's really what they were asking for in that second litigation. And I'll add one more kind of atmospheric point that I think also counsels in their favor on this. The Fifth Circuit itself was not committed to its res judicata analysis. It didn't just say, the plaintiffs shouldn't be in court, we're going to throw this suit out. It said, we don't think that they should be in court, and also now, let's go on and weigh in on this major constitutional question about the legality of Texas's statute. Well, that's not normally how courts do business. There's a principle of constitutional avoidance. And if they really thought that they were right about their res judicata analysis, they shouldn't have addressed the merits at all. What they were likely doing strategically was trying to make their case a poor vehicle for Supreme Court review. They were trying to create a vehicle problem. And we suggested this in our amicus brief, that you don't want to, as a Supreme Court, encourage appellate courts to say that the litigants shouldn't be in court in the first place, but also we're going to make a big constitutional decision that now is effectively unreviewable by a higher court. I'll leave it there.
Just a couple of quick follow-up questions. First, why do you think I don't know if you have any insight into why the plaintiffs didn't petition for certiorari the first time around. And then also, doesn't the argument that the plaintiffs shouldn't have challenged, that the fact that there would have to be rulemaking and the precise requirements that would apply to abortion providers have yet to be determined, isn't that somewhat inconsistent with what I take as a basic theme of the plaintiff's argument, that the Texas legislature intended this law to maximally burden abortion providers, and thus one could quite fairly assume that whatever regulatory process proceeded, the end point would be the imposition of every conceivable surgical center requirement on abortion providers. So the argument that, well, we need to wait and see what the world would look like after the regulatory process concluded, isn't that somewhat inconsistent with a claim about what the Texas legislature was up to?
So the first question about why they didn't appeal or seek cert after the first case, I think it was a strategic reason, basically. There was a fairly unfavorable decision for abortion rights advocates in 2007, Gonzalez versus Carhart, and that was the first time that Robertson and Alito, both being on the court, had issued a decision, and I think that the abortion rights committee was worried what would happen if they went back to the Supreme Court. And they finally got to a point after they lost the second Texas case where they felt like it was just going to have to take their chances, but they were willing to live with that first decision, I guess, because they feared that there would be worse consequences. As far as the second issue, wait, now what was the second issue?
The second issue was the surgical center requirement. There had to be rulemaking
Sure.
and the like.
Yeah, well, so one answer is, I'm not suggesting that they could not have challenged it earlier. But as a litigant, you want to wait until you feel like you have a solid case. And they wanted first to make an argument in the administrative process that some of their existing facilities should be basically grandfathered in. And they they wanted to have that opportunity to make the argument. Now, you can also imagine, had they brought the suit initially, the state of Texas very likely would have said that it was premature, precisely because the regulations hadn't yet been issued. And so, even if they thought the most likely outcome was that they were going to be subjected to a harsh provision, I don't know why a court would want them to sue prematurely and wait until the controversy really matures.
So I am somewhat, and I hope the audience will forgive us for continuing on this procedural point, although I'm also very excited about it, so right now. But one thing, I sort of think that my own thoughts about this are somewhere between the two of Rob and Dave. And one of the reasons for that is because there's these terms, facial challenges versus as-applied challenges, and I'm not sure how many have encountered these terms, but in my mind, they're some of the least helpful terms used in American case law. Sometimes when we talk about facial challenge, sometimes that's shorthand for a pre-enforcement challenge. Sometimes it's shorthand for a substantive theory of law, which goes to your point, which is to say that if we're going to challenge this abortion regulation because we think the intent was improper, then that's in a sense a facial challenge to that law. We're challenging the law regardless of what it does. It's because it was enacted with an improper intent. So there's the pre-enforcement way of talking about it, there's the manifestation of it, there's the substantive theory manifestation of it, and sometimes when we talk about facial challenges, we're just referring to the remedy that we're requesting, which is to say, regardless of when we're bringing it, regardless of the theory under which we're bringing the challenge, what we want as a remedy is for the whole law to be invalidated. And here what we have in this case is just a mismatch of all of this. So the initial challenge was pre-enforcement for facial. They had a substantive theory that it was facially invalid, and they were seeking a facial remedy, right? So you have all of that. In the post-enforcement challenge, it's now post-enforcement, so in a sense it's as applied, but they're still bringing up some of the same substantive theories. So you start to feel like there's an overlap there. And at least by the end of litigation, they were again seeking a facial remedy. So that's why, in some respects, you read Justice Alito's dissent and you think this really does seem like the same challenge. They just have a better record now, and they're bringing the same challenge again. But the flip side is that if we were to adopt Justice Alito's theory here, we would not really be letting plaintiffs bring both pre-enforcement and post-enforcement challenges, which is actually something that the Supreme Court wants plaintiffs to be able to do, to bring both these types of challenges. So it's a tough issue, and I think incredibly interesting, for what it's worth.
Well, enough procedural foreplay. Let's move on to the substance. So 3 questions that I'll just pose to the panel, and I invite anyone to chime in. The first is, does the whole women's health opinion make forging new doctrinal ground? Putting aside the res judicata, and there's also a severability issue that's quite interesting. Putting those aside, does the case forge any new doctrinal ground? Is it indeed the case that there's this abortion-specific application of the 14th Amendment for these cases? And then, does Justice Thomas have a valid concern that there shouldn't be this kind of splintering of constitutional analysis based upon the substantive context at stake, that there shouldn't be this abortion-specific silo? So I'll just pose those and invite people all to respond. We can also go back to the civil procedure.
I'll take a shot at the significance of it. In preparing for this, I saw some commentator that observed that the case was doctrinally insignificant, but ideologically ominous in terms of its decision. And I don't know if that's right, but in terms of the first part of it, I mean, it's Justice Breyer's opinion is a very fact-specific opinion. It's all about the record that existed or didn't exist with respect to these particular provisions, and how they burden women's right. And so, in that sense, you could say it's a straightforward application of the undue burden test, and very dependent on the facts. On the other hand, this is the first time that the court had really addressed in length the undue burden standard since Casey itself. I mean, there was the Carter decision earlier. So in that sense, any application of it, I think, is significant. But I think much like the prior case, I mean, what is made of this case will depend a lot on which justices come to the Supreme Court in the next decade.
I'll jump in a little bit. I am not a student of the abortion cases. I've never litigated in the area, so I just have some observations. I'll be curious to hear the professors talk about, hopefully, how these restrictions compare to restrictions in previous terms that were upheld, as you noted, Professor Marcus. There was a fairly unbroken string until this time. But three observations. I actually, based on my really limited knowledge of the law in this area, I think that if the operative test is undue burden, I agree with you that it's really hard to find these as being anything other than that. I actually thought that even though we're now in the construct of substantive due process in the abortion context, that equal protection analysis might have helped out here, because equal protection analysis does tend to lend itself to pretext analysis. And here you could have looked at the issue of what other medical procedures are required to have these admitting procedures. What other medical procedures are required to have surgical center nearby, or the requirements for those. If the answer is none, then you're pretty well dead under the equal protection clause. If it's a lot, then you're probably fine. So it would have been interesting to see that. I did note a paucity of federalism issues. It was Justice Kennedy who, I believe, wrote the right to die case in Oregon, who waxed poetic about the tremendously broad authority that states have to traditionally to protect health and to regulate health. And so I didn't see any sort of balancing test here, which I gather is fairly common, tracing back to Casey. But the one question I would weigh in very heavily on is Justice Thomas's suggestion about, is there an abortion silo under substantive due process? It sure looks that way under this analysis. I would argue, however, that this test is, the undue burden test, is more consistent with the purposes of the 14th Amendment than the rational basis test. So I might differ with him on which test ought to be applied. And if you look at the history of the 14th Amendment, which constitutionalized the Civil Rights Act of 1866, there are a whole host of rights, including the right to earn a living, that have been subjected to almost no judicial scrutiny whatsoever, that were clearly intended to be protected by the 14th Amendment. And abortion, clearly, I'm aware of no evidence that abortion was intended to be protected by the 14th Amendment. It was brought in through the privacy rights under the Bill of Rights. So it seems to me that there shouldn't be that silo, but rather than jettisoning it in the abortion area, I think it would be more doctrinally consistent and historically consistent to extend that type of analysis to other types of government regulations.
Well, so let me first address the doctrinal significance of the case, and then maybe this broader question. So doctrinally, I think that basically the opinion did help clarify a couple of genuine ambiguities that have been left over from Casey. So the first one was, you read some language from Casey about what undue burden means. And in some of the formulations that the court gave in that case, they talked about undue burden meaning substantial obstacle. And so did undue burden just refer to the extent of the burden that was being imposed? Or did it require some balancing? So the Fifth Circuit's view was, as long as there is a rational basis for the regulation, then we just look to see how burdensome it is. And Justice Breyer rejects that reading and says that actually, no, you need instead to look at the strength of the rationale behind the regulation and kind of compare it to the burden that it's imposing. And, is the burden worth it? Are the benefits to health significant enough to make it worthwhile? And his answer is a clear no once you do that balancing. And the second question that he answered was this denominator question that you flagged, which also had been left ambiguous in Casey. When you're challenging an abortion regulation on its face, Casey says that it's unconstitutional if it has an undue burden on a large fraction of women. But it was unclear what the large fraction was. Was the denominator all women of reproductive age, all women who might seek abortions, all women who might seek an abortion and actually be directly affected by the regulation? And Justice Breyer does weigh in pretty clearly and says that the answer is basically about that very last one. So he shrinks the denominator down, which will make it easier for plaintiffs to challenge abortion regulations in the future. So I think those are for me, those are the two doctrinal takeaways. And this bigger question about Justice Thomas's view, is abortion treated differently? Well, I think it is. His point is that it's treated differently in a more favorable way. Abortion gets special treatment as a right. And that doesn't seem correct. I mean, when you think about substantive due process and other fundamental rights under substantive due process, you're in the strict scrutiny world, usually. And the undue burden test is less protective than strict scrutiny, not more protective. And so I don't know that I agree with his notion. And other people in the anti-abortion community make this point, though, they call it the abortion distortion, that courts go out of their way to give favorable treatment to abortion rights. And I just don't really see that.
I want to turn it over to the audience, but just very quickly, while we have Greg Garr on the panel, both in the Seventh Circuit and in the Supreme Court, the defenders of these abortion provider restrictions they got hammered by Richard Posner and Justice Ginsburg for insisting that the facts of the world simply aren't what they are, defending a law that's clearly pretextual, that the evidence doesn't really support the claims that the state made in support of these laws. Have you ever been in a position where you had to argue that something is what it really isn't, and been in a position like the Texas Solicitor General's defending the law in this manner. What do you do in that situation?
I mean, first of all, in the Supreme Court, there are two different kinds of cases. There's sort of the 9-0 cases that you never read about, where the justices kind of roll up their sleeves and do what lawyers do. And then there's sort of hot button cases that you read about and they're decided by war. And those cases are entirely different when it comes to oral argument. Usually when I argue a case like that, what my wife says to me when I'm going off to court that morning is, don't worry, no matter what you say, it won't make a difference. Because justices are coming in and have pretty strong views about what their position on the issue is. And so in this situation, you know, it's a difficult situation to be in as an advocate. And you know, I actually think that the advocate here did a pretty good job of answering Justice Ginsburg's question directly in a way that was kind of matter of fact and didn't seek to elevate it. So in that respect, I think he did about what he could do with a record that I think was challenging. In terms of other things you can think about as an advocate or a new court participant in that situation, first is look for help. I mean, turn your body a little bit, look at Justice Bollock and say telepathically, you know, I need some help here. Justice Scalia was not on the bench for that oral argument. And another is to give your answer, you know, yes, that's right, this is what the record shows, and then pivot. You know, try to go to res judicata, which was a stronger legal issue for him, or one of these other arguments, try to pivot. And then maybe you know, also, ultimately, if you're forced to stick on the facts, then maybe ultimately you start thinking about, well, maybe, you know, if we had an opportunity to remand, put in additional evidence, or argue that this was just deference to legislative judgment. You know, those are things you could think about, but the fact is I don't think there was a magic bullet here.
So, no matter what you do, your work is pointless. That's not,
Not in cases we win.
Right. So we only have about 4 minutes, but I'm going to go ahead and use my prerogative to extend it to 6 minutes, so we can get one extra question. Any questions about this case for the panel? Yes.
One question about the issue of a pretextual challenge. On the trial level, is there any indication that the plaintiffs attempted to, in this age of emails and memos, attempted to subpoena emails and memos from legislators to determine whether or not somebody explicitly intended this law to be a pretext, or do you know if that ever happened?
I'll let the panelists address this, but in this case, they didn't have to. The plaintiffs didn't have to. They just had to look to Twitter. David Dewhurst, the Texas Lieutenant Governor, who under Texas's somewhat strange system of government is probably the most powerful state official and certainly in charge and presiding over the legislature, he tweeted a picture of a closed clinic right after the bill passed and said, "We fought to pass SB 5 and here's why." So, you know, come on, Lieutenant Governor Dewhurst, keep your mouth shut. So I don't know that discovery was, or a form of discovery, FOIA, open records subpoena, was really necessary to make this case. He then deleted the tweet really fast, but you know, Twitter lives on in perpetuity.
They did raise a discriminatory purpose claim in the case, and in fact it did get briefed all the way up to the Supreme Court, but the court instead addressed it based on the undue burden standard rather than looking for, rather than getting into pretext, which was a choice on Justice Breyer's part, I suppose. But there was plenty of evidence that they had ready access to.
Other questions? Andy?
So I forget which of the dissents made which of these points, but I thought that one important part of the dissension argument that abortion receives special treatment, special scrutiny on the part of the court, was that the court applies special procedural rules to make it easier for plaintiffs to litigate these abortion cases. And one of the rules I remember one of the dissents talking about is the standing rule and the really relaxed application of the capable repetition yet evading review standard in this context. I just wondered if the panelists had any thought about that sort of procedural kids or alleged instance of procedural kid gloves treatment in the abortion context.
I also don't really see it there. The court has applied third-party standing doctrine and the capable repetition mitigating review standard in other contexts. I mean, they have a third-party standing case where they granted third-party standing to a beer vendor, right, to challenge a statute that had a different drinking age for men and women, right? And the relationship between a physician and a patient is one that we would likely recognize as more intimate and special than the beer vendor-vendee relationship. So again, I don't know that I see it procedurally either.
There might be about 40,000 people across the street at our undergraduate institution might disagree with that, but anyone else want to?
Well, I would also just quickly say that, I mean, standing doctrine is not, and really all these procedural issues we're talking about, this is not a matter of the Supreme Court trying to interpret a statute, for example, that Congress enacted and, sort of interpreting it one way with respect to some rights and another way with respect to other rights. I mean, this is the court looking at a couple of words in the Constitution and extrapolating a heck of a lot from that, which is just a long way of saying that these are the court's, in a sense, the court's own rules. And to the extent that they interpret them in a way to allow themselves to review certain things, I mean, I'm not sure that it's necessarily that problematic to think that those rules would change based on the circumstances of given cases.
Okay, last question.
I'll ask a curiosity one. So throughout the court's history, they each kind of found different places for the right of abortion. I was just wondering what each of the panelists, perhaps not what would win with the court, but in your personal experience, where you think the abortion argument is strongest? Is it penumbra's privacy? Is it the Ninth Amendment? Based on your experience, where do you think the strongest argument lies in your belief?
Doctrinal, based on current past case law, which is not actually responsive to your question, but at this point in time, I mean, that's the strongest argument, I would say.
Well, I'll give a shout out to one of my former bosses, Justice Ginsburg, who I think believes, actually, maybe not so dissimilar from your position, that the Equal Protection Clause might be a stronger constitutional provision to emphasize.
I actually thought that abortion was on very weak jurisprudential ground until the Casey decision. And even Ruth Bader Ginsburg, before she became a justice, had been critical of the rationale underlying Roe versus Wade, which I agreed with. And Justice Kennedy really, if my recollection is correct, based it on the protection of liberty under the Due Process Clause of the 14th Amendment, and I thought that was the best and to me personally most persuasive that I've seen. And when you think about that decision, now it's kind of accepted as a baseline proposition in this area of the law. At that time, the situation was that the right to abortion was on very, very thin ice, and a lot of people, a lot of court forecasters thought that Roe was going to be overruled altogether, and instead, I think the Casey decision put it on firmer constitutional ground than it had ever been before.
I mean, really, if you look at this decision, one of the more interesting aspects of it is if you look at the dissent, it's really all focused on sort of procedural reasons as to why the other side should lose. I mean, you don't see the sort of more fundamental challenges to the law in this area that you would see if you go back, 10, 15 years, at least to Casey. And so, there is a sense in which the focus has changed a little bit.
Okay, we'll break. We're a little bit shorter than the schedule suggests. We'll reconvene at 2:45 and continue our discussion with United States versus Texas. Okay, we'll get started with our third session. We'll be discussing a case that where the court was unable to reach a decision, split 4-4. So we'll be talking about a case that's in somewhat of an odd posture for these proceedings. This is the United States versus Texas case. I thought about just growling a lot, rather than saying anything by way of summary, just going grrr the whole time. I might lapse into that, I warn you in advance. On August 1st, 2014, a district judge in Brownsville, Texas, named Andrew Hanen, issued a remarkable opinion. In 2007, Judge Hanen sentenced an immigrant named Ben Ramirez to 5 years in custody after he pled guilty to illegal reentry. After finishing his time in prison, Ramirez filed a motion asking for a change to the conditions of his supervised release. Now, a lot of immigrants convicted of illegal reentry get deported upon finishing their time in custody, especially immigrants like Ramirez, who have a lengthy rap sheet, including several violent felonies. But Ramirez had received asylum and now wanted to move from Los Angeles to Louisiana. Judge Hanen was apoplectic. How could someone convicted of multiple felonies, as Ramirez had, be granted asylum? Now, one possibility is that our asylum system is notoriously haphazard, one that has long produced totally arbitrary results. There's a lot of data and dispassionate analysis to support this conclusion. But Judge Hanen thought otherwise. Based on this single case, one of 250,000 that immigration judges had decided in 2014, Judge Hanen concluded that the Obama administration must have developed a new policy of privileging hardened criminals when it comes to granting asylum. Hence, with a remarkable breach of judicial decorum, we're not recording any of this, are we? With a remarkable breach of judicial decorum, Judge Hanen wrote a 10-page screed not resolving a case or controversy, but complimenting his own prowess as an expert on immigration and predicting the implosion of the United States from the phantom policy he had divined. Now, Judge Hanen was right about one thing. The Obama administration was indeed in the midst of devising a new immigration policy. But here's the great irony. It was the opposite of the policy that Judge Hanen, exemplifying the paranoid style of American politics, predicted. Grrr. Back in 2012, I just had to clear this out a little bit, bear with me. Back in 2012, the Obama administration announced its Deferred Action for Childhood Arrivals program, or DACA. DACA was for the so-called dreamers. We've all heard of the dreamers. The federal government would grant what is called deferred action to people ages 31 and under who had arrived in the United States before the age of 16 and had lived in the country for at least 5 years. There were other eligibility criteria as well, including the immigrant must have completed high school or be engaged in an education program, and importantly, could not be convicted of most crimes. Now, this was deferred action. It's not legal status. Dreamers are still not here legally, but they would get a form of lawful presence. They would get work authorization and not have to fear deportation. In November 2014, 4 months after Judge Hanen uncovered the mysterious Obama administration plot, the administration announced its real change in policy. It announced its deferred action for parents of Americans and lawful permanent residents, or what's called DAPA. Now, DAPA is a lot like DACA, but for parents. It's designed to protect against breaking up families. Like DACA, DAPA had a 5-year residency requirement. Like DACA, DAPA disqualified any parents who had criminal convictions. And like DACA, DAPA would extend deferred action, not legal status, to parents for potentially renewable 3-year stints. The idea was to give relief from deportation and work authorization for up to 3.7 million undocumented immigrants. Now, DACA's and DAPA's goals were obvious. In 2011, the Director of Immigration and Customs Enforcement, John Morton, determined that the United States, based on what Congress was willing to fund, ICE had a deportation capacity of about 400,000 people per year. But the problem is there are 11 million undocumented people in the United States. So John Morton said, look, we need to use our deportation resources wisely. Hence, he issued memoranda asking ICE agents in the field to exercise their prosecutorial discretion, prioritize the removal of convicted felons, and make law-abiding parents of U.S. citizen children low on the priority list. Now, these memos encountered massive bureaucratic resistance. Indeed, the head of the ICE agents union sued and insisted that this request was unlawful. ICE agents simply didn't comply and did not use enforcement resources in the manner that Morton asked. So one can think of DAPA and DACA as the Morton memos, but with more teeth. Rather than hoping that ICE agents would honor agency preference, DAPA invited immigrants to come out of the shadows, register, and get deferred action before they're served with charging documents telling them that they're to be deported. On December 3rd, 2014, the state of Texas, along with 25 others, including our beloved Arizona, sued the United States in the Southern District of Texas Brownsville Division to enjoin the implementation of DAPA, not DACA, the Dreamers one, but DAPA, the one for parents. There are only 2 active district judges in Brownsville, so the state had a 50% chance of getting the case assigned to Judge Hainan. And lo and behold, this is what happened. Now this is great. This is the answer to Hainan's greatest worry. ICE has the resources to deport 3.6% of undocumented people living in the United States, and DAPA would ask that these resources be used against felons, not otherwise law-abiding mothers and fathers. Now, of course, this is not how Judge Hainan saw it. The state of Texas and 25 others argue that DAPA is illegal under the Administrative Procedure Act and unconstitutional under the Take Care Clause of Article 2, Section 3 of the United States Constitution. Judge Hainan agreed. On February 16, 2015, he wrote an 85-page opinion enjoining DAPA's implementation nationwide. The Fifth Circuit upheld Judge Hainan's order in November of 2015. The case went to the Supremes, and the Supremes couldn't decide. There's a split 4-4. The Fifth Circuit's order remains in place. Grrr! Now, as a matter of policy, the wisdom of DAPA, to my mind, is indisputable. A recurring theme of the litigation before Judge Hainan was that the federal government wasn't doing its job, that is, enforcing immigration law. Indeed, one of the state of Texas's arguments for standing was an abdication theory. If the federal government has plenary authority over a particular area, like immigration, but does not discharge its responsibility, it abdicates, the states can sue. By implication, the state of Texas must believe that only by fully enforcing the immigration law would the United States not be abdicating. But what would full enforcement entail? What would the deportation of 11 million undocumented people require? Well, one conservative think tank did an estimate and calculated the cost at $400 to $600 billion. By point of comparison, ICE's annual budget is $5 billion. So ICE would have to grow by a factor of at least 80 to accomplish what the state of Texas believed it should. Now, the policy alternative the states seem to prefer, this so-called full enforcement, to my mind, is the fever dream of a South Texas judicial miscreant. In light of a world of scarce resources, DAPA is eminently sensible. Surely it is better, as a policy matter, to channel scarce enforcement resources toward their best use. But it's not policy but law we have to discuss today, and here's where things are arguably a little less black and white. The Supreme Court granted cert on 4 questions or something like that. I'll say that they did. They might have actually granted cert on fewer or more, but I have 4 listed, and so that's what I'll say they did. I'll mention these questions and then invite the panelists to weigh in on each. First, does Texas have standing to sue the United States under Article 3? What particularized injury would DAPA inflict on Texas? After all, DAPA does not require Texas to do anything or abstain from doing anything and so forth. The Fifth Circuit's analysis on this issue is complicated, but it boiled down to this. First, states warrant special solicitude in the standing calculus, as the state of Massachusetts enjoyed when it sued to challenge the EPA for failure to regulate greenhouse gas emissions. Second, Texas would have to grant driver's licenses to DAPA residents. Since Texas subsidizes each driver's license to the tune of about $130, DAPA would inflict significant economic costs on the state's fisc. My question to the panelists is this: if a state has standing to challenge any federal policy whose incidental effects include an impact on the state's fisc, what limits, if any, remain? Second, can Texas sue under the Administrative Procedure Act? The APA does not allow challenges to agency actions that are, quote, committed to agency discretion by law. The idea is that agencies have scarce enforcement resources, and we don't want courts second-guessing how agencies deploy them. The Obama administration says, look, DAPA is just one big statement of how we plan to exercise our enforcement discretion, and it shouldn't be reviewed. The Fifth Circuit says, no, this is not what DAPA does. DAPA is not about declining to prosecute. It's about granting a benefit, i.e. deferred action, which gives the immigrant lawful presence and along with it eligibility for certain social welfare benefits, temporary social security number, and so forth. Now this issue gets deep into the weeds of immigration law, but one response seems pretty straightforward to me. Consequences always flow from a decision not to prosecute. Here's my question to the panelists. Wouldn't the rule against the review of a decision not to enforce disappear if the consequences of that decision justify review? Third, should the DAPA policy have gone through notice and comment rulemaking? Now, I teach administrative law, My students never believe me, but this stuff is actually pretty interesting. The APA requires so-called legislative rules, that is, agency actions designed to be prospective and have a legally binding effect, to go through notice and comment rulemaking. In contrast, agencies can issue so-called policy statements to guide the enforcement of or administration of policy without going through this process. Agencies can kind of roll out of bed and look themselves in the mirror and say, let's have a policy statement. Now, the quintessential example of a policy statement is a guide to how the agency plans to use its enforcement discretion going forward. The Fifth Circuit said, well, look, while DAPA is supposed to allow ICE officials to deny deferred action to any particular parent on a case-by-case basis, that is, while DAPA is ostensibly not binding, it doesn't really leave any room for discretion going forward. Hence, DAPA is legally binding. It's supposed to have prospective effect. It's binding on ICE officers, and thus must have gone through notice and comment rulemaking. So here's my question. How can an agency adopt an enforcement plan designed to deploy scarce resources intelligently without running afoul of the APA? And then finally, does DAPA violate the Take Care Clause? Article 2, Section 3 of the United States Constitution requires the President to take care that the laws be faithfully executed. The state of Texas says Obama has breached his constitutional duty because his DAPA policy is essentially the repeal of immigration statutes. This important constitutional question begs another for the panelists. Isn't part of the faithful execution of the laws a reasoned and sensible decision about how best to enforce them? The court's deadlock left the Fifth Circuit's decision in place and immigration policy in total limbo. So what will happen next? The case will go to trial in Judge Hagan's court in a couple of months. His total incapacity to demonstrate anything resembling judicial decorum leaves the outcome in no doubt. The appeal of the inevitable permanent injunction will go to the Fifth Circuit, which probably will affirm it. After a rehearing on bonk, the case will likely, a petition for certiorari will likely be filed, and I expect the Supreme Court to grant it. Now, of course, all of this will happen unless Donald Trump gets elected. What President Obama can do with the stroke of his pen, President Trump can undo with the stroke of his own. If that happens, or if the Supreme Court ultimately sides with the states that sued, Judge Hagan will get the immigration policy he announced as so dangerous back in 2014. That is, a chaotic mess, one that doesn't insist upon the sensible exercise of discretion in the name of public safety or humanitarian values. Grrr. Okay. Let's see, what are my questions? I'll just start by saying, tell me why I'm wrong or answer my questions.
Let me just start with, in part to relieve myself from actually having to deal with the substance of the questions first off the bat. One tiny little amendment to your what comes next story. I believe that the United States did file a petition for rehearing.
Oh, right.
And in July, and the Supreme Court will consider that at the end of this month. And the government's position basically is, let's have this heard again when we have 9 justices. The court has denied similar petitions in a couple of other cases where it's split 4-4, but the government argues that this case is uniquely important. And so we'll see. It's possible that the court will hold on to it and not give Judge Hagan another shot quite yet.
There's some other interesting sort of collateral litigation involving this issue. A case filed in the Eastern District of New York, for instance, to try to argue that the injunction entered by the judge here is overbroad. And my understanding is that there's some hope that that will proceed on an accelerated basis, with the understanding that January 2017 and the inauguration of the new president lies around the corner. So I'd be interested in your thoughts about, let's start with the constitutional question, the big kahuna. Did President Obama violate the Take Care Clause when he created the DAPA program?
I mean, I'll start just by observing that I think, one of the issues that was really important to the litigation of the case, which is implicit in your summary, but I think important to emphasize, is that there's this question of whether or not the executive had simply made a decision not to exercise, to prosecute people. So it's an exercise of prosecutorial discretion. They weren't going to commit their resources to that. But then the opponents of the memorandum said that really it went further. Not only did they decline to prosecute those people or to send them out of the country, is that they actually conferred what the memorandum called that they were lawfully present. and that lawful presence therefore triggered various benefits, which is what the state was challenging. So I think, I mean, it was interesting at the oral argument, Justice Kagan was very savvy about finding ways to get the court, get to 5 justices who agree with her position, actually sort of suggested, why don't we just sort of nix out the lawfully present language of the memorandum? And, you know, the government sort of indicated that maybe it would go along with that, but it never, it was a little bit ambiguous on that. So I think, you know, both sides sort of, I mean, a lot of the framing in terms of what was at issue depends on what you think about the significance of this lawfully present language, and whether you view this as simply a decision not to exercise, to allocate your resources in the way that you do to prosecute certain people, not others, which is certainly much easier to defend constitutionally, or a decision to actually confer a status on these people that the House of Representatives, Congress repeatedly had refused to confer, or at least was unable to pass legislation conferring it, which sounds like the executive conferring substantive rights that the legislature was unable to enact, which I think is harder to do.
First of all, I can't remember any other cases under the take care clause. So if there have been, I'd really love to hear about them, because this is a new ballgame to me. But I will claim some prescience. Do you say prescience or prescience?
You're the justice.
Well, I'll say prescience today. In 2013, I co-authored a book called Immigration Wars with former Governor Jeb Bush. The high point for this book is during the presidential debates when he said you could get it on Amazon for 79 cents or something like that. But, and we proposed basically junking the immigration laws as they are right now and rebuilding them from scratch. And a lot of what we advocated is reflected in DACA and DAPA in terms of what to do with people who are here presently illegally. But one of the things that we argued was that this has to be done by legislation. It must not be done by executive order for several reasons. First of all, as you pointed out, Professor Marcus, what can be done by executive order can be undone by executive order, and if people have come out of the shadows, which you want them to do, suddenly they will have identified themselves if the executive order or executive action is repealed. Second of all, we thought that this action, by unilateral action by the executive, would undermine the consensus that's necessary for immigration policy. But third, and this gets to the big kahuna, we argued that it would be unconstitutional for the president to act unilaterally. If you look at the Constitution, it gives the executive branch no authority, no express authority to regulate immigration, and it provides Congress with the power to regulate naturalization. So, so we were very, very concerned that it would be done in this fashion, and sure enough, when the executive action was taken, it was challenged. You a couple of times used the words program and policy when you were describing this, and I think that those were revealing, because I do not see this as an exercise of prosecutorial discretion, but rather as a program or a policy that was created by the executive. It may be a great program or policy. In fact, I think it is, except that he doesn't have the authority to do that. And I think if you want an example of prosecutorial discretion, you look at the marijuana enforcement memorandum, which basically says, as I understand it, in states that have legalized marijuana, we are not going to prosecute. But when you establish a new legal status, it does two things. First of all, it does give the state standing, because it has, as Texas demonstrated, a domino effect. Suddenly, Texas's expenses go up by virtue of this new legal status, and it takes it outside of the purview of prosecutorial discretion into the realm of policy making. Does this mean that it needs to be, it needs to go through the Administrative Procedure Act? I'll defer to you on that because I didn't do well in administrative law in law school. But I think that at a much more fundamental level, when this case gets to the issue of whether the executive displaced a statute, I think that we have predicted. I have predicted the outcome of that with Governor Bush. But the other aspect that I would emphatically agree with you on is that this abdication theory would not yield standing. That the notion that the government's failure to enforce a law would, that it seems to me is a far more indirect effect, and I think that Texas latched onto. I was fairly dubious on standing when I saw this lawsuit, and then when I saw the effect of the new legal status on Texas's driver's license system, I think they got it, and I think that the circuit got it right.
Well, let me just if I can jump in, a couple of things. One is, and this is the weeds of immigration law that I don't purport to understand. But my understanding, having said that, I do understand that there's an important distinction between legal status and lawful presence.
Lawful presence.
Yeah, and the presence, lawful presence, would tap into a long-standing and congressionally authorized category, this deferred action category, that not only that has Congress recognized in the INA itself, albeit in different parts of it, but the Supreme Court has referred to in its own decisions about what the executive can do, what the Attorney General can do. And I guess my question is, if there's this long-standing and well-accepted practice of telling an undocumented person, look, we're going to give you deferred action. And this is something that Congress has acquiesced in, sometimes explicitly. The Supreme Court has said is perfectly fine. Why does that become an unconstitutional assumption of power by the president when it's done on a large scale? Why does the scale matter so much? When it's well accepted that on an individual level, the Department of Justice or the executive can extend this kind of recognition, lawful presence, on a case-by-case basis. Why does it then necessarily become unconstitutional to do the same for categorically, by saying we want to do it for this category?
Well, two reasons that I can think of. One is that it was intended to be exercised on an individualized basis under the congressional recognition of this. And second, when you're making a decision about the deployment of law enforcement resources, you do necessarily have to embrace categories, but by virtue of doing that, you are not investing a person with a type of legal status. And I guess I fail to see a meaningful distinction between legal presence and legal status.
I wonder if other panelists want to weigh in either on the constitutionality question, the standing question, something that came up in Justice Violet's remarks.
I'll take standing. And I'll confess to have argued Massachusetts versus EPA behalf of the EPA and have lost it. But just to give some context, in that case, the argument was, and the Supreme Court by a 5-4 majority found, that the state of Massachusetts had standing to challenge the EPA's failure to act on the theory that failure to act today was going to cause to rising sea levels that was going to hurt Massachusetts like 100 years or so in the future. And the Supreme Court said that they had standing to raise that challenge and invoked what at the time seemed relied upon a case no one had really cited in the briefs and said that there was special solicitude to the state. And so in this case, by contrast, the University of Texas is going in and saying, this memorandum is causing us direct financial impact. Just for example, because of these aliens who are affected are now lawfully present, we have to issue them driver's licenses. And that's going to cost us money, millions of dollars, or real money. And the government's response to that was, well, no, you don't have to issue them driver's licenses, so you really haven't shown injury. Well, the problem with that argument was in the Supreme Court when the justices asked, well, if Texas doesn't issue driver's licenses, you're going to sue Texas, right? And because they're going to sue them for not carrying out their federal obligations. And the SG never gave a direct answer, but in effect the answer was, that's right, we're going to sue you. So in that situation, how then could the state not have standing to challenge that direct financial injury? And when you compare that with Massachusetts versus EPA, I mean, I think Texas certainly has a more conventional standing of injury than Massachusetts did in that case.
So my question in that regard, in the driver's licenses thing, I don't think Texas made the argument the marginal cost of issuing additional driver's licenses was $130 per person, but that it costs on average $130 a subsidy. And without showing the increase in the marginal cost of issuing these licenses, how has Texas made the requisite standing showing? I appreciate that under Massachusetts v. EPA, it seems like a pretty minimal threshold. But I wonder, was Texas relieved of the kind of evidentiary burden it should have shouldered for the standing?
Well, I mean, its argument was that it was going to have to issue all these new licenses that it wasn't otherwise going to issue because these people were designated lawful present. And it also had arguments about additional benefits for healthcare and the like.
So I think the standing question is very difficult, and it's difficult both with the technicalities of the doctrine and then also bigger picture structural issues of what you want standing doctrine to do. On the special solicitude issue first, I mean, that was sort of a weird, unexpected thing that the court said in Massachusetts versus EPA. And so you might think, well, that was just a one-off situation. And in fact, when the court talked about special solicitude, they talked about special solicitude when a state's quasi-sovereign interests are at stake. And so Massachusetts' argument there was that global warming would flood state-owned lands, and they have a sovereign interest in the protection of their territory. And the notion that your state might have to pay a little bit more out of the public fist to issue driver's licenses doesn't feel sovereign in the same way. So I wonder if the court would extend the special solicitude doctrine in this context. Even if they don't, I think it's not. I mean, I think there's a decent argument that Texas should have standing. Although I wonder what the difference is between Texas's position and instances in which the court has found that there's a generalized grievance. So if an individual had sued and said, we think this policy is unconstitutional and it will hurt us because we will have to pay more in taxes if more driver's licenses are being issued, they get thrown out of court. And so should Texas be able to raise a similar argument as a state institution? And I don't really know the answer to that because it does have big implications for federalism and the separation of powers. It means that states play a bigger role in sort of being a watchdog when the federal government does something they don't like, and you may think that's a good idea or a bad idea. And it also gives the court a bigger role in policing the federal separation of powers, because what the state is doing in this case, and might be doing in other cases, is saying that the executive is overreaching and essentially circumventing Congress. And so granting standing here does have those big structural implications.
So it's funny, whenever I don't really know the answer to something, I feel like it's generally because I haven't done my homework and it's my fault. In this case, I feel like it's not my fault. Well, first, it's extraordinarily complicated, but then also, this case to me confirms that we need a functioning Supreme Court. We're faced here with the prospect, if this litigation goes through in the Eastern District of New York, we could have two circuit court opinions in direct conflict as to whether this federal policy is legal or not. And we happen to have a time issue in terms of how long President Obama will be in office. But it nevertheless is possible that we'll have essentially different immigration policy or standards, or whatever you want to call it, in different parts of the country, because the Supreme Court is deadlocked 4-4. But here's the thing when it comes to this case, it's not only DAPA, which is incredibly important, it's not only DAPA that's at issue. Each one of the questions that you flagged for us we don't have answers. What is the standing, what are the standing rules here? We don't know because there's this theory of special solicitude for the states. The Supreme Court has talked about it in Massachusetts versus EPA. No one understands what they mean. The court alluded to it actually in a case that came out of Arizona, where your legislature wanted to sue the Independent Redistricting Commission, and the Supreme Court had to answer questions of standing, and they suggested that maybe there was some theory related to this that helped them have standing. Now we have it here, and we just don't know what it means. The questions about the APA, those sound very technical, and they are very technical. But at the end of the day, these are big questions about when can under the APA, well, and you don't have to talk about the APA, just generally speaking, is it possible to challenge governmental action before it happens? If so, how do you prove that the four corners of a seemingly guidance document actually constitutes a binding statement? These are important questions we don't have answers to. And the take care clause, as the justice pointed out, we can all read the Constitution, but otherwise there's not a lot to interpret it. So my basic response to this case is that this is showing that we're in a bit of a problem right now.
Why do you think the court granted cert on the take care question? The Fifth Circuit didn't address it. It was all an APA case. So why do you think the court, is it just that the court wants to take these meaty questions on, it's fun for the justices? I don't know if you all have more perspective on this than I.
Well, I think the court that granted certiorari had many justices, and I think it's a very different court than the court that decided the case. Obviously, it's before. So, in terms of the questions, it's unusual for the court to add a question where the parties are well represented and they've laid out the questions. That is unusual, but it happens from time to time, and it suggests that at least one justice was able to convince three others that they should add this question. And so here, clearly, there are four justices we know that seem to side with the state, and at least some component of that coalition, including Justice Scalia at the time, seemed to feel strong enough about that issue that they wanted it briefed and considered.
One theory that I saw, which I think is total speculation but seemed plausible to me, was that maybe the court added the question just because it would allow them to dispose of the whole case. And if they had left that question open, they would have had to remand it to Judge Hainan, who may then have taken on the question for the first time, and the Supreme Court actually wouldn't have accomplished much by its decision.
So should we talk about administrative law? That's one of my there is a genuine, I understand, all my gurring aside, I do understand the complexity of this issue. On one hand, first of all, the fact that agencies can promulgate legally binding policy itself is a big constitutional conundrum. The legislative power is vested in the Congress. To what extent can that power be delegated to an agency? But one of the safeguards against the abusive exercise of delegated legislative power is to require that legally binding, prospectively oriented legally binding policy go through notice and comment rulemaking. Here, the DAPA policy seems to be a response to the reluctance of street-level bureaucrats, the line ICE officers, to abide by the preference that they administer the immigration laws in a particular way. So this is a much sort of stricter set of instructions. That seems like legally binding policy. On the other hand, if this isn't lawful under the Administrative Procedure Act, then how does an agency ensure that rationally created, sensibly thought through policy objectives actually get implemented on the ground when the agency has to rely upon the discretion of line officers, line officials? Maybe there's no answer to that.
Is that a rhetorical question?
No, it's an actual question. If this sort of policy has to, or maybe the answer is just go through notice and comment rulemaking, and that's fine.
Well, I think one question is why the administration didn't put this through notice and comment rulemaking. I'm not sure that it would have made a difference in the ultimate outcome of this case, given, as you say, that the judge at the district court level was seems to be quite hostile to what the government has done here, and the challenges just keep getting deeper and deeper. So if they had done it through notice and comment, then you have the argument that it substantively violates the APA, and then if you lose that, you have the argument that it violates the Constitution. That being said, the government would have had an easier time arguing this if they had sent it through notice and comment.
Yeah.
I'm not sure if they regret that decision.
You might.
I was going to say, it's interesting, thinking about the application of the APA suggests that ultimately, this should have been an executive decision. It was just the way about the way that they went about doing it. I think one of the more interesting aspects of this case is it wasn't just the United States versus Texas, and Texas and other states in the United States, but the House of Representatives actually took the somewhat unusual, though certainly not unprecedented, step of intervening in this litigation, filing an amicus brief and presenting an argument before the Supreme Court as well, taking the position that, look, under the Constitution, and this gets back to the Justice's point, we have the responsibility to make the immigration laws. Constitution vests us in Article 1. Yeah, it's true that we weren't able to pass legislation. We've had this back and forth politically, but that doesn't mean that the executive can sort of take that over and issue the decision that when the legislature has made act. So you can think of that as the government being dysfunctional in a way that is bad policy, depending on which perspective you take. But it is interesting to think about this case involving a battle between the states, the executive, and the legislature. All with different interests in terms of resolving this question.
I have a theory about why the administration didn't go through notice and comment rulemaking. My guess is that, first of all, it's a very protracted process, and the Obama administration had its eye on the clock, hoping that it could get this done before his second term concluded. And then also, once it went through notice and comment rulemaking, of course, the inevitable challenges to the lawfulness of the rule would ensue under the APA, which would simply extend this even beyond the lengthy period of time it would have undertaken to go through the notice and comment process, and that I would guess that's the reason why. I have a question about what Greg just said. Does the fact that Congress has proven systemically incapable of addressing immigration, at least since the George Bush's second term, and arguably from before then, does that strengthen the argument that in the interest of having a sensible, rational immigration policy, that the president can step in? In other words, that there should be some, when you're thinking about the take care clause, there should be some recognition of institutional reality, of sort of recent history, the capacity of the other branches to discharge their job. There's an irony here that Texas argues about the president's abdication. Well, you could easily make the same argument about Congress's abdication. Justice Falk, I don't know if you have a reaction.
Well, I would say absolutely not. The exigencies do not expand presidential power, or I should say gridlock does not expand presidential power. It's frustrating as someone who's passionately advocated for immigration reform. It has really been a source of tremendous frustration that the House has refused to act. But that is a very strong reflection of democratic processes. People are sent to Washington with the express mandate to not reform our immigration laws. And if the president has Trump power over the, there was a
the Trump has presidential powers, I think
if the president can leapfrog those democratic processes, I think that that really damages the rule of law. And again, I think that one of the reasons we have such gridlock on the immigration issue is the perception that immigration policy does not adhere to the rule of law. And if the president takes unilateral action, that only further undermines it and I think makes the situation worse rather than better.
Yeah, one response that I have had to looking into these issues is that I think that by framing it in a way similar to how you just framed it, President Obama ended up undermining the legal case for what he did. So, some of the quotes that then the the courts pulled out and put into their opinions by President Obama, he was saying things like, quote, "It was the failure of Congress to enact such a program that prompted him to change the law." So the change the law is coming from President Obama. Same thing, I take executive action only when we have a serious problem and Congress chooses to do nothing. You know, if you're going to say that what we're doing is simply non-enforcement, it's simply executing the law that's on the books, it's not great framing if you're saying, I only do this when Congress has chosen to do nothing. So I think although sort of from a policy perspective, everything you're saying makes sense. You know, if we have gridlock, doesn't it make sense as a matter of policy to allow some reforms to go through in different ways? As a matter of constitutional analysis, I think it makes it more problematic if that's how you frame it.
I want to take a very different position. I mean, I also think that it is sort of tempting but dangerous. The laws that you're executing are the same laws, whether Congress is gridlocked or not. But I guess there is in constitutional doctrine, and this actually is not something that I thought about before this, and so I'm not going to remember the details, right? But presidential power does, I mean, there is doctrine that suggests that how much power the president has depends in part on, has Congress specifically foreclosed what the president wants to do versus been silent versus given approval. And maybe within that framework, there is some way to account for the practicalities of a world in which Congress is just not acting, and as long as the president isn't actually flouting a law that's on the books.
I mean, I think that that's right, certainly in terms of the framework. I guess, the counter argument that Texas would probably make is, and that certainly the House of Representatives would make, is that Congress has acted. I mean, it's not like we have a blank slate and the president just said, well, let's do it this way. I mean, we have a set of laws that, arguably the policy here, not even arguably, according to the president, the policy here changed. And that's, just typically not the way it's supposed to operate.
I have this question that I circulated to the panelists before we convened that I'm very proud of, involving organoleptic testing, which is smelling fish to determine whether it's spoiled or not. And somehow this does connect to our discussion. But instead of going through the elaborate way in which it does, I'm going to open up the room for questions to see what you have to say. Yeah.
Mine is more of a comment that, if anybody wants to correct me, I'm not an attorney, but having a legal presence just means you've got a card in your wall that says, I can be here. It doesn't have the definition of classification of why you are here. Are you a Class B, a Class L, a Class K, what are you? And each one of those designations has a purpose of why you're here and a period of time and a process to what you have to do in order to stay here beyond that, or whether you have to go home. And I suspect that he was using this, as you pointed out, Professor Mannheim. Congress wasn't acting, and by identifying those people, giving them legal presence, then means they show up in the immigration, they can do their job. They can then look at each one of these cases and decide, okay, you're this class, you're that class, this starts defining how do you function here unless you apply for citizenship. And in the meantime, they also have to pay taxes. So I suspect he was using it more as strategy to identify all these people that are causing potential security threats through Homeland Security, as well as police powering, take the police off their backs just so we can all move forward and get them processed properly. So it's just a comment. If there's any questions in there, I don't know. But and if I'm incorrect, please advise me.
I don't know if you're incorrect, because I think that the law here is very complicated and esoteric, and I certainly will confess to being not an expert on it. I do think that, one of the more interesting aspects of the oral argument transcript was when the Chief Justice asked the Solicitor General, do you mean to say that you can be here, be in the United States in violation of the law, but nevertheless be lawfully present? And the Solicitor General said, yes. And Chief Justice sort of said, what?
So you
So
don't have a
the-
car in your?
Well, I don't know. I mean, I'm just saying, I think part of it is just the terminology. And I do think, getting back to what I said earlier, a lot of this case, and it's true in a lot of Supreme Court cases, is about framing. So if you think that the lawfully present language isn't really doing any work, isn't conferring rights, it's just sort of describing a situation that already legally exists, then I think you're just saying this is simply a decision not to prosecute case, which is something that the executive tends to do more often, and it certainly at some level has the authority to do that.
Well, I think all of the reasons that you stated for the executive action here are absolutely apt. I think it rises to the level of a compelling interest that the president was trying to serve. But there were two things that I think really cut against it, in addition to some of the other things that were mentioned here. One is that it transformed the legal status. These individuals were here illegally and now were present legally, and that in turn set in motion a number of consequences. The other was the hoops that you had to go through and everything, which again resembles more of a program. The administration and previous administrations already prioritize who they're going to deport. For example, if you've committed a felony, guess what? You're at the top of the list. And this administration, conservatives hate to hear this, but this administration has deported more illegal immigrants than any previous administration. So it's not like this was a simple abdication. But if the administration had simply said, you know what, we're going to deprioritize these types of removal type situations, I don't think we'd be in this status. But because the president was frustrated, as many of us are, with the congressional inaction, he went further, and as a result, I think he went beyond his boundaries.
I do want to say one thing about terminology, which seemed to flummox a number of the judges and justices involved in this litigation. And it's a little bit frustrating because while the terminology is complicated and the immigration law side of this is incredibly dense, it's a real thicket. Ultimately, I don't know why the judges and justices involved in this litigation didn't feel like it was their obligation to familiarize themselves with these terms and how they're used. Judge Hainan seemed to use the terms lawful presence and legal status interchangeably, but they have very, very different meanings under immigration laws. And I think that I completely understand the kind of initial knee-jerk, what do you mean that they're not here legally, but they have lawful presence? I mean, the terminology is very confusing, but it isn't it's not fabricated for the sake of this case. It is long-standing terminology that goes back many decades. President Reagan gave Salvadorans lawful presence in the 1980s, a deferred action to relieve them of the consequences of deportation for a certain period of time. It's just, this happens periodically. It's a way to administer the immigration laws a little bit more in a more nuanced way. I want to say one of the arguments that came up, that the administrative law piece of this turned upon to a certain extent, was whether there was indeed discretion to deny this status to someone who came forward and attempted to register. There's a lot of argument about this, but one of the important things is that people have to kind of come forward, they have to self-identify as potentially eligible to receive this status. So it's not a situation where the administration can use this program policy, whatever you want, as a way of kind of ferreting out security risks and the like. It's quite likely that only those people who really thought they would have a good shot at getting the status would take the risk of coming forward and saying, hi, I'm undocumented, and I hope I can get this status. So in that regard, I'm not sure it was a...
They are by no means home free.
Right, yeah. And so, but someone who is a security risk or is a convicted felon, I would be skeptical of that person would take the risk of coming forward. Andy?
You just alluded to this a little bit today, but I wonder if any of the panelists would comment on just how new DACA and DAPA really are, just how much of a change they represent over previous, deferred action practice of previous administrations. My understanding, maybe this is wrong, is that every previous administration, going back to at least Ronald Reagan, exercised the deferred action authority, which Obama is purporting to exercise here, and that at least in some cases that authority has been exercised categorically without going through the notice and comment practice. Maybe in the case of South-Dorothy Reagan, I'm not sure exactly which cases were involved, but am I right about that? Am I wrong about that? And if I'm right about that, Justice Bullock, doesn't this just look like a pretty ordinary exercise of administrative authority delegated by congressional statute?
Well, to my knowledge, none of those previous deferred actions were challenged. But beyond that, this was, to my understanding, I mean, I can't profess deep knowledge of the prior ones, but by virtue of the standards, the application process, the consequences of work permits and so forth, this is a far more elaborate, it's deferred action plus deferred action on steroids, whatever, you know, and I certainly wouldn't say that the prior ones were necessarily valid, but this was certainly a difference in magnitude, both size, but also in terms of the complexity and depth of the policy.
So I think, and I agree with that, I mean, I think that there's an interesting debate in the briefs on this, because prior historical practice is something that the Supreme Court looks to a lot in these sort of separate cases. And I think that was one of the more challenging things for the states to deal with. But I mean, I think the arguments they were making is that those prior instances involved the exercise of foreign affairs powers, where the president has a greater constitutional standing under Article 2. And also, I think the House argued that they actually, they're bolstered legislative authority, but I think, there you get into a real debate about, is that really true? I mean, I think you have to look at each instance.
Yeah, I'm wondering what was enjoined here, how you would craft an injunction that doesn't infringe upon normal agency discretion to prioritize their actions.
I think you just enjoin the whole thing and let them start from scratch. I don't think you redraw it.
That's essentially what, so there's a preliminary injunction in place now. Ultimately, it's to be determined what the permanent injunction will include. But it essentially enjoins, it just as if the DAPA never existed. Now, there's an interesting issue as to whether a single district judge has the authority to enter a nationwide injunction. And my understanding of the law of remedies is that a judge can, if it's simply impossible to remedy the harm without enjoining the entirety. I don't see how that's the case here, although I certainly think Professor Mannheim's point about multiple immigration policies in different parts of the country is a good one. But I think that's a really interesting issue as to whether Judge Heenan has the power to issue the scope of an injunction that he issued. I don't know if other of you have thoughts on this.
Well, if the injury that's being asserted, I mean, the injury that was the basis for standing was these extra costs that Texas is facing through the driver's license program. Well, to remedy that injury, you certainly don't need a nationwide injunction. You just need a remedy that applies to Texas. And if other states would not incur those costs, then they have not had a similar injury and might not want the program enjoined. In fact, they might realize that there might be some economic benefits to them associated with it. So it does make that broad release questionable, and I think that's part of the reason why there's now that Eastern District of New York case that you mentioned.
Right. Yeah, the plaintiffs in the Eastern District case are arguing, in fact, that the administration acted unlawfully in honoring this injunction. That the injunction is so transparently invalid that the administration has now acted unlawfully under the Administrative Procedure Act by denying this program to people in New York and the other states where they didn't participate in the litigation. Andy, you get to ask the last question.
Well, let's assume you're right about the scope or the overbreadth of the injunction. What is the appropriate remedy is it to file suit in the Eastern District of New York, or is it to seek reconsideration from the district judge or to appeal the scope of the injunction to the Fifth Circuit? And what did the administration do, if anything, on that front?
So I don't know if I have a legal question for you, but Rob and I are actually talking about this a little bit, and we think that if the judge in Texas throws some government officials in jail for contempt of court, then maybe that will move the Fifth Justice one way or the other on the Supreme Court. So it's a matter of strategy. Maybe you keep going until you get that. I don't know. But as a legal question, I think it's very complicated.
Greg, I'm sure probably knows more than any of us about this, but often if the remedy is narrower, the government has a couple of options, right? It might decide if a decision is made in one circuit that it will honor it elsewhere, or it will decide to try to challenge it somewhere else and generate a circuit split.
Right. And this part of the case is not new or novel. I mean, the government has seen these nationwide injunctions in many cases and have argued it, and it just hasn't been resolved.
The possibility that some administration officials might be thrown in jail is not there's more than a 0% chance of that happening. Judge Haynes has essentially held the entire Department of Justice in contempt. I can't quite figure out exactly why, but I think, if I understand correctly, every member of the Department of Justice is obliged to undergo 3 hours of ethics training and the like due to some mysterious failure to do something or other. But I couldn't figure that out. I was exercised enough over what I did figure out. So, that's enough of that. We are now reached the part of the program that I'm particularly excited about. We're going to discuss Justice Scalia's impact on the court and on the law. And I think for this part of the program, we've invited the panelists to offer a few minutes of reflections before there's a discussion. So I'll just turn the floor over. So we'll just go down the row. So Professor Mainheim, you're up.
Oh, thank you. I just came up with a few minutes worth of remarks about Justice Scalia's effect on the law and on the court. As you will see, my theme is that it's complicated. So at the outset, Justice Scalia was a conservative icon. That's clear. Beyond this, though, it's difficult to understand or to assess what effects he has had in the law. And this is because Justice Scalia's influence, while unquestionably significant, didn't actually make it into a lot of majority opinions. So he didn't affect the substantive doctrine as much as one might have thought. I think that comparing him to another justice, who in a sense is his mirror image, is helpful in thinking about these issues. And that mirror image is William Brennan, who is just...
I was going to say that.
Good, okay, good. I'm glad I get to go first. So Justice Brennan, I'd love to hear your thoughts on this. Justice Brennan is described as a liberal icon just about as often as Justice Scalia is described as a conservative icon. Unlike Justice Scalia, though, Justice Brennan was a consensus builder, which is to say that he worked to put together majority opinions. And this quality allowed Justice Brennan to change the substantive law in a way that continues to shape the way that we all think about the court and the Constitution. As one conservative magazine put it in describing Brennan, one could argue, and I should say that I think this is an amazing quote, that, quote, "there is no individual in this country, on or off the court, who has had a more profound and sustained impact on public policy in the United States." So that's what the National Review said about Justice Brennan. And I don't think anybody would say that about Justice Scalia. And it's not close. One fact on that, when NPR listed 5 important decisions of Justice Scalia for its listeners to go read, 4 of those decisions were dissents. Yet, despite all this, Justice Scalia served for decades as perhaps the most influential leader of a very powerful legal movement. So again, the legacy of Justice Scalia is complicated. When we dive in a bit deeper, a few things do become clearer. And we see his influence emerging in at least 2 respects. First, Justice Scalia is a representative of a movement. He already has an endowed lecture at Harvard named after him. He has a law school named after him. In the last year, multiple Republican candidates have singled him out as a model for who they would like to appoint to the bench. He is, and I think he's going to remain, a symbol of and a symbol for the conservative movement. Second, Justice Scalia also helped to change the way that people talk about and even think about the law. Again, not only that necessarily changed a lot of the substantive doctrine, but rather at a higher level of abstraction. As both an academic and as a judge, he insisted that legal thinkers focus first and foremost on the text when dealing with statutes, and also that they care more about original meaning when addressing the Constitution. And so as a result of this influence, we now have someone like Justice Kagan, who I know recently visited this law school, and who is generally considered to be a liberal justice, declaring that, quote, "we are all textualists now." And to be clear, Justice Scalia and Justice Kagan, they disagreed about plenty of things. But what Justice Kagan means by this is that just about everybody at this point in time starts with the text when interpreting a statute, just as Justice Scalia demands that we do. And that's to some degree a shift from how courts and legal thinkers thought about that in the past. Also, as a result of Justice Scalia's influence, we have just about everyone at this point in time thinking about original meaning when interpreting the Constitution. So we have someone like Justice Stevens, for example, engaging in an originalist argument relating to the Second Amendment, even when he disagreed with Justice Scalia about where that same analysis should lead. So as a result of this influence, originalism has become a familiar mode of analysis. And again, that was not always the case. So that's just at the top, at the Supreme Court level. But textualism and originalism, as ways of thinking about the law, they've trickled down to lower courts, to the academy, to how students learn about the law, and even to discourse by non-lawyers. This is a big impact to have on the way that people think, and it's a real accomplishment. So in short, while Justice Scalia may not have been able to move the substantive law in the ways he wanted it to go, he did have a profound effect on how courts, lawyers, and even those in the general population think about legal questions. This all said, if you'll bear with me for just one more moment, there is another facet of Justice Scalia's work that I think, in my mind, should be addressed when discussing his impact. And this doesn't go directly to what he accomplished, but rather the means by which he accomplished it. And to put it bluntly, Justice Scalia at times could be offensive. I don't think this was an accident. I think, to the contrary, he really reveled in making blunt, provocative, and controversial statements. And it worked. It got attention. It helped to spread his views about the law. That being said, I think it came at a cost. And part of this is that when you read some of his opinions, particularly, for example, those addressing matters of sexual orientation, they can be hard to read. And I think that that's going to get worse with time. It's going to be, those reactions may get stronger with time. His at times antagonistic tone also undermined, I think, his substantive impact to a certain degree. Because, like I said, he wasn't the consensus builder that someone like Justice Brennan was. Finally, I think just as a matter of rhetoric, it could wear a little bit thin. And I say this in part because I know that law students often will look to it as a model for writing, which makes sense insofar as it's so clear and so vivid. But when you read the fiery dissents and the scathing opinions and the impassioned writing, when you read enough of it, you start to feel a little bit like the villagers in the Aesop's fable. Sometimes the wolf is there, and it makes sense. But sometimes the wolf's not. And then you start to lose a little bit of trust in what he's saying when you see so much of it. So anyway, I bring this up because I do think that Justice Scalia's style and rhetoric and tone, I think it's a significant part of his legacy. I think it helped to get him where it was, he got, but I think that it may make some of his legacy not hold up as well as it might otherwise. So in short, Justice Scalia's legacy is complicated, and I would love to hear my colleagues' views of how that is the case.
So I started thinking about this a little bit differently because we're here at the Rehnquist Center today, and I started thinking about Justice Scalia compared to Chief Justice Rehnquist. And I think you see some similarities and some dissimilarities. Sort of interestingly, they were both sworn into their final positions on the same day. Justice Scalia as Associate Justice, Chief Justice Rehnquist as Chief Justice. Chief Justice Rehnquist's first act as Chief Justice was to swear in Justice Scalia. They both served as head of the Office of Legal Counsel in the Nixon administration. They both shared a conservative judicial philosophy and certainly agreed on many occasions. And they were two of the only three justices to have died in office in the last 63 years. So they shared those similarities. At the same time, they were by no means joined at the hips. They had strikingly different styles Chief Justice Rehnquist, he tended to be more laconic in nature, whereas Justice Scalia, while very close to members at the farthest left of the course, like Justice Ginsburg, still was very acerbic in style. Chief Justice Rehnquist would oftentimes hold his nose and go along with the decision to get to 5, in a way in which I suspect Justice Brennan perhaps did sometimes. Justice Scalia would pride himself on never giving in, would always write separately if need be. And although they agreed many times on decisions, ironically, they oftentimes famously disagreed. Justice Scalia's certainly probably his most famous dissent, and maybe one of his most famous decisions, is this dissent in Morrison versus Olson, a decision that the Chief Justice wrote. When Justice Rehnquist died, Justice Scalia said that he had lost, it was a double loss for him, he had lost a friend and his chief, and I suspect Justice Rehnquist would have said that he lost a friend when Justice Scalia left the court. In thinking about Justice Scalia's legacy, 3 things stand out to me. One, what Lisa just said about Justice Scalia's impact on the way we think about the law in terms of interpreting statutes most fundamentally, and then also in terms of originalism and how to think about the Constitution. I don't think you can underestimate the impact that that has had, because as Lisa says, and I absolutely agree, it starts at the courts, trickles down to the academy, and trickles down to law students. And that completely changed. If you go back and reread Supreme Court decisions from before the time that Justice Scalia entered the bench, you get to the interpretation of statute, they almost would go first to legislative history, first to speculating. And now, even the most liberal justices on the Supreme Court will agree, as Justice Kagan observed, that you start with the text. And that impact, I suspect, is going to be far more lasting and significant than any particular doctrinal impact which could come or go with the change in the makeup of the Supreme Court. Second, Justice Scalia almost single-handedly changed oral argument at the Supreme Court. As an advocate, you get an hour. Both sides get half an hour, but each case is argued for an hour. And before Justice Scalia took the bench, oral arguments consisted largely of attorneys walking up to the podium with notes and just reading them with an occasional question sprinkled in here and there. And the day that Justice Scalia took the bench, he almost single-handedly changed that to the point where now oral argument over the course of a half hour is not unusual to get 70 questions or interruptions. And do the math, it doesn't give you much time. And that's Justice Scalia. And I'll just give you one example from this past fall of what it was like to argue for Justice Scalia. It was sort of the good Justice Scalia and the bad Justice Scalia from the advocate's perspective. And if he was on your side, there was no better person to head up there fighting your battles. And if he wasn't, it oftentimes wasn't fun. In this particular instance, he sort of intervened when another justice was giving the advocate a hard time about what Congress intended. This is a case called Spokane versus Robbins about standing and had to do with Congress's intent and whether they established particular harm. Justice Scalia says, Mr. Pincus, I would have thought that your answer to Justice Kagan would have been Congress did not identify as a harm for which it allowed the suit to be brought as misinformation. It did not, Justice Scalia said. It identified the harm as failure to follow the procedures that it imposed upon accrediting agencies. So in fact, Congress has not identified misinformation as a harm. That's not what the statute does. And Mr. Pincus, the advocate, says, and I apologize if I hadn't been clear on that. And Justice Scalia says, isn't that your answer? And the advocate says, that's exactly our argument. And that's an example of which, a way in which Justice Scalia would come to an advocate's side, and for better or worse, advocate his own position. And certainly there was the good Justice Scalia in that respect, and the bad Justice Scalia. The last thing I would say on his legacy is, although he certainly will be remembered as a conservative icon, I agree with Lisa, I think it's also important to appreciate, and this adds to the complexity of his record, that he wasn't just sort of a cookie-cutter conservative. There were areas in the court which he could conventionally be viewed as liberal, where he was sort of leading the charge. For example, he almost single-handedly revamped the law on the Confrontation Clause, ultimately gave criminal defendants more rights in that area. He was a strong proponent of the rule of lenity. in interpreting criminal prosecutions. And particularly in the last decade, the court became a strong advocate of the Fourth Amendment and procedural protections in the Fourth Amendment. And so I think when you think about the replacement of Justice Scalia with someone like Justice Garland, at least on those particular issues, if you look at their records, you can imagine the court actually moving to the right. So I think it's important in thinking about Justice Scalia that he wasn't just sort of a knee-jerk conservative across the board. I think he sort of relished as much as anything the situation where his originalism, his way of reading the statute, led him to the result that was sort of, not the conservative result, conventionally speaking, but that's where the law led him, and that's where he ended up.
So I agree, I think that both Lisa and Greg, that probably his legacy, the most lasting part of his legacy will be his methodological contributions, which have had and will continue to have a huge effect. I also agree with Lisa that he was a polarizing figure. And there's a lot to what Greg just said about how he was not actually reflexively conservative. But his critics, I think, would more or less take that position, that he was largely a political actor who often maybe used his methodologies to seek results that were convenient for him. And there are counterexamples of that, but that would be a critique that I think you would hear. And there is some chance that that critique will gain traction as his legacy. And I actually think that that would be a shame. And part of the reason that it would be a shame is it does diminish his methodological contributions. It suggests that if he really was just using these methodologies instrumentally, maybe the methodologies aren't worth very much. But there is a lot to be said for his methodologies. I mean, the notion that we're all textualists now, we're all originalists now. We may differ significantly on what we mean by originalism, but everyone's doing that. So I just wanted to give an example from an area of law that I think about quite a bit, and so does Lisa, which is election law. Trying to maybe explain a few different types of election law cases that Justice Scalia was deciding, and show that there really was something underneath them. You could read these cases and think, oh, he's just acting in a political way, he's doing what he, maybe as a partisan Republican, would want. But really there's a unifying theme, and it's important to recognize the logic that's underlying that and engage with it. Because even whether you agree with it or disagree with it, one of his important contributions was that intellectual heft that he brought to a lot of what he was doing on the court. So, election law. In the last few years, we have had Citizens United, which deregulated campaign finance, and a number of other decisions have gone in the same direction. And Justice Scalia was a big proponent of that. A generation ago, he had dissented in this case, Michigan Chamber of Commerce versus Austin, which Citizens United overruled, essentially adopting the Scalia position. So he was very deregulatory. He wanted there to be freedom to spend money in politics. He believed that the First Amendment protected that right. So that's one aspect of what he did. At the same time, he seemed relatively indifferent to voting rights. So there was a case that the Supreme Court heard in 2008 called Crawford versus Marion County, which upheld a voter ID law from Indiana. And Justice Scalia was in the third of the court that was most willing to defer to the legislative choice to enact this law, even if it imposed burdens on some voters. He was unsympathetic to the notion that voting had to be especially easy for people. The third aspect of his election law jurisprudence is he was largely protective of the prerogatives of political parties. So he had one case, California Democratic Party versus Jones, where he said that a California scheme that took the ability, it diminished the ability of political parties to select their own nominees, that this was constitutionally problematic, it violated their associational rights. Well, so how do you tie all three of these cases together? I mean, one answer is to say, well, that's what the party line would have been in all of these cases. But actually underlying, and you get a hint of this in some of the language that he uses, is he actually has a coherent vision of democracy that ties all of this together. And it's sort of a classic pluralist vision of democracy, where what the democratic process is about is really this clash of interest groups and people competing with each other. It's not the sort of hand-holding vision of participatory deliberative democracy. It's not necessarily this classic Republican vision that we want to elect people who are going to act in the public good. It's that no, democracy is the result of conflict, people coming together and fighting with each other and hopefully that reaching the best answer. And for that to work, you want a deregulated campaign finance system. You don't care that much about whether everyone gets to vote. You care that the people who care about things are able to get to the ballot box, or that interest groups are able to mobilize their supporters. And you want strong political parties, because those political parties are going to be able to channel these competing interest groups. Right? They funnel them into coalitions, and that's a useful thing. And so, underlying all of this is a democratic vision. And there's one particular aspect of this democratic vision that I particularly like, and that is his notion that democracy is something that, he really did care about democracy, I think, and felt that it was something that people needed to engage in and fight for and fight about. So there was a case that came to the court 5 or 6 years ago called Doe v. Reed. And in that case, there were some people from Washington State who had signed a ballot initiative, a ballot petition, that was going to put an anti-same-sex marriage proposition on the ballot. And they later wanted their identities to be protected from public disclosure. And you might think that substantively, Justice Scalia was aligned with these anti-same-sex marriage proponents who signed this ballot proposition. So maybe he would be sympathetic to their argument that they should not have to disclose their identities because they would risk retaliation and it would make them uncomfortable. Well, he was the least sympathetic member of the court to this position. He talked about how there was no right to participating in our democracy anonymously. And he said, concluding his separate writing, "For my part, I do not look forward to a society which, thanks to the Supreme Court, campaigns anonymously, and even exercises the direct democracy of initiative and referendum hidden from public scrutiny and protected from accountability or criticism. This does not resemble the home of the brave." And so that vision of people who really care about democracy and actively engage with it, I think is one of the things that for me will be part of Justice Scalia's legacy.
Well, when I heard of Justice Scalia's death, I had the exact same reaction as I did many, many years ago to Justice Brennan's death, which was the court has just lost one of its titans. And although they were extremely different, Justice Brennan was the master of schmooze. He almost never asked questions at oral argument, which is about as far from Scalia as he could possibly get. And Scalia was the outsized personality on our current Supreme Court. I think that basically what it comes down to in terms of their impact is that both of them are irreplaceable, in my opinion. Brennan has not been replaced. We have not. We've had liberal justices. We've had brilliant liberal justices, but we've not had anyone with the kind of strategic vision and abilities that Justice Brennan had. And I suspect that no matter who is elected president, we're not going to see someone with the type of towering personality and clear vision of the world and jurisprudence that Justice Scalia had. So I think that the court will be worse off for it. And for the relatively brief time that they were both on the court, I thought we were in the era of Babe Ruth and Ted Williams playing together at the same time. Substantively, I would quarrel with my co-panelists on his contributions. I think in a couple of areas in particular, he was the driving force behind the substantive advances that the conservative majority experienced. The intellectual force and frankly the face on these issues more often than not. The first is in the area of private property rights and in particular takings. I think this was Scalia's baby. He wrote the key decisions in this area and really advanced the law from an area of law where there was not much to takings jurisprudence when he started, and when he finished, the area of law was much more robust. Same thing, and perhaps even more significantly, with congressional authority under the Commerce Clause. I think he had a very clear compass. There were essentially no limits to congressional power under the Commerce Clause when he started on the court and when he finished. There are, I don't know how long they will last, but there are some significant limits on that authority. The third area of law where I thought he had a major impact, and I'm only discovering this now as a justice for the first time in my career, really grappling with criminal law issues, and I definitely have a civil libertarian bent, and I find very often that my star on the Supreme Court in so many opinions is Justice Scalia, often has the swing vote in these cases. It was the one area where he often swung the majority, and it was Justice Breyer who would often switch sides and make it a 5-4 decision on the liberal side with Scalia there. So I do think that he viewed the rights of criminal defendants in criminal law under the Bill of Rights very significantly, and I'm enjoying discovering just how much that is the case. Professor Mannheim, with her discussion of how even liberals were influenced by his focus on textualism and statutory interpretation. One of the first things that happened to me when I joined the Arizona Supreme Court is that my most liberal colleague told me I needed to buy Scalia's Reading Law. And indeed, it has been the book I have consulted more than any other. He was a real craftsman and really drilled down. I mean, how many Supreme Court justices write an incredibly dense, co-author an incredibly dense book on statutory interpretation? I know his co-author had an awful lot to do with it, but seeing him on TV programs talking about it, man, this guy really, really knew what he was talking about. And then I began with the personality, and I'll end there as well. Yes, he did have a really acidic personality sometimes. I'm sure he drove his colleagues crazy, especially Justice O'Connor, who was often the target of his scathing dissents or commentary. But he was also wildly entertaining. I remember taking my oldest son to the U.S. Supreme Court for the first time, and when we left, he said, "Dad, I really love Justice Scalia." And I said, "You've got to get this one right. It's Scalia." One of the things I absolutely loved about him that I plan to emulate about him as best I can is he didn't just mix it up on the court. He mixed it up in public forums all the time. He was the public justice more than anyone else. And he loved, as you probably all of you have seen at least one of these debates with Justice Breyer. I mean, who did more to bring constitutional law into the real world and really, really engage in public debate and commentary than Justice Scalia? I will so miss that. He was one of the funniest people I've ever seen. In fact, I recently in a conference used one of his lines about statutory interpretation, which is garbage in, garbage out. If they give you garbage, it's your oath-bound duty to issue a decision that's garbage in return. And he really was, in so many ways, larger than life. And I think that his legacy, both substantively and in terms of methodology, will be with us for a long time to come.
Thank you very much. Those were really wonderful. I watched a number of versions of these sorts of panels in preparation for today. I think it's fair to say this is by far the most interesting, so we really appreciate it. We're at 4:15. We're licensed to go till 4:30, but I fear that everyone's in the room is getting a little bit worn out. I do want to ask, Greg, if you don't mind, do you have any war stories? arguing in front of Justice Scalia? Anything that jumps to mind?
Yeah, let's see, the last time I argued before him, he suggested that African Americans might be better off at slower track schools, and that would be justification of policy. So that was a sort of a, interesting thing to deal with. But that I was in, that was a unique exchange. But one thing I will say about Justice Scalia is that I loved arguing before him generally, that he would engage, he would ask questions, and he would listen to answers, and there was a real give and take. I mean, I think, some justices are just using the questions to make points. And with Justice Scalia, I mean, he just loved the give and take of oral argument, and that was a sort of special experience to be a part of. Whether he was with you, or against you usually, but when he was on your side, there really was no better justice than him.
I'm going to go ahead and take my prerogative as moderator to call these proceedings to a close. First, I just want to thank our panelists for coming to visit us here today and for what was a really remarkable conversation. I can't really think of a better way to pay homage to the Constitution than to have something like this. I think it really exemplifies what the Constitution is all about. So we're very, very grateful that you've come. Thank you so much. I also want to thank Sally Ryder, Andy Cohen, and our Dean, Mark Miller, for organizing this event and supporting it. I think it's a real important moment in the law school's calendar, so thank you very much, and I look forward to subsequent iterations.